and today's subject is constitutional law. We have 4 hours set aside for it, but I think we probably will not need quite all of it, although we may exceed 3 hours. I think we'll be able to get through it in a little bit less than our allotted time. As I often do, I'm going to reorder a couple of pages, not too many actually, in this particular section. And there's one question to which I'll draw your attention where I'm not entirely sure about the answer. We'll talk about the issues and why I feel that way. As our materials note, and which is certainly correct, the version or the portion of constitutional law that is part of the MBE is a particular and in some ways strange subset of the entire law that you studied in con law, perhaps in the class that you took, with or without the First Amendment in it, etc. Some courses include it, some schools break that out into a separate course. Constitutional law is, of course, a large, complicated, very nuanced area of the law. But it can't be tested that way, right? That is, the only things that can show up on the MBE are things where there are clear right and wrong answers, which in many situations in the con law class that you took, or if you've done any reading in the area, right, it kind of contradicts everything there. There are no clear answers, there are no clear rules, there are multi-factor tests and gray areas and so forth. And as a result of that means it's good news for you in the sense that the constitutional law material that's tested has to be pretty clear. And once you familiarize yourself with it, it should be pretty easy to avoid wrong answers, and you're not going to be called upon to make difficult judgment calls. And again, our materials note that. Our materials, and I will emphasize some of this as we go through, also include a good deal of strategy as well as the actual content. What kinds of answers tend to be right answers? What kinds of answers tend to be wrong answers? And it's worth familiarizing yourself with that, as well as learning the actual material so that you won't just be relying on some strategic tip, but will actually know why. That is, there's a difference between eliminating an answer as a possible choice because it says always or never, and it tends to be an extreme overstatement in an area of the law where that's rarely the case, and actually understanding the rule. That is why it is that such an answer is incorrect in a particular setting. So the first of these sort of half strategy, half content rules we find on page 30, answers that state, that is in our shaded area, answers that state that the governmental authority in question can always or never perform some specified action should be viewed with extreme caution, right? Because they're overstatements and tend to oversimplify, and it's rarely the case that the governmental authority, be it the executive, a law Congress has passed, or at the state level, can never do the sort of thing described, even if they can't do it in the situation which is in our fact pattern. So question number one, which may have sort of confused you a little bit when you first looked at it, because you said, well, where's the question, right? That is, this is just a structure, right? It's a call of the question and answers, and the idea is if you see any federal statute, right, that is a description of any federal statute doing almost anything at all could set up this kind of question, right? So our question, just as she's stepping out, question number one on page 31. All right, so again, whether we would see a question structure like this today, I'm not so sure, because that's a question structure that makes it impossible to anticipate the answers, right? Even if of course we can't anticipate it if we don't have a federal statute and some facts. But even if we did, right, the way that they now test kind of strongest argument style is not exactly this way. Again, it doesn't mean we should be familiar with the content, but this is the kind of question that forces you into the answer, so you have to read all of the answers in order to figure it out, rather than being able to anticipate and generate an answer and then go looking for it, which is often more effective when it's possible. So now we just have to start reading through answers. Begin. Right, so what's the problem with that answer? Again, we can't necessarily totally eliminate it because we don't know what else is coming. But what's wrong with that answer as an ideal answer? Well, part of it is because you actually know the law in the area, right? This is one that's often taught about what the federal government can regulate on the interstate highways and so on. But what I want to draw your attention to here, just again, because we don't know, the law could be about anything, right? I mean, here we're given highways, but that's really a placeholder for the concept here, which is the states ceding their authority over X, right? Sharing it maybe, giving some of it maybe, ceding their authority over X, unlikely to be the right answer, right? Right. Correct, and there are some situations we can generate where the federal government has all the authority, right? Federal lands that are located inside a state or something like that. But then that wouldn't even be the state ceding its authority. That would really be the federal government asserting its authority, right? So that's, I mean, again, even apart from what we know about the law of highways and how that, you know, the federal government pays for it and the interstate highway goes to various states and so forth, even apart from that, you want to look out for that language, the state ceded their authority, because that's unlikely to take you where you want to go. Next answer? Okay. Why is it wrong? I mean, it's wrong a few ways, again, in content terms, but also structurally. I mean, what are the words that should be the red flags in that answer? Right. And then the reason makes it even easier for you to see that it's wrong, right? Because if the federal government could do that, that wouldn't be why, right? It would be the necessary and proper clause, or right, something like the commerce clause. It wouldn't be because they paid for most, they didn't even pay for all of the construction costs, right? So you kind of are given two ways to see that that answer is probably wrong, right? That without limitation, and then even if you were tempted to into that, the reason's a bad reason. Okay? See? Okay, what do we think of it? Right, now we're actually thinking about the content of the law and what gives what in the Constitution, even though it's not mentioned here, gives Congress the power to enact a law. I mean, now, having read these laws, we know exactly what those facts must say, right? The federal government pays for most of the highways and then imposes a 55-mile-per-hour speed limit. It's challenged. Here's our question. The best argument for the constitutionality would be. So this is at least an argument for the constitutionality that makes sense, right? It puts this within Congress's legislative authority for the right sorts of reasons, right? We might be able to imagine in the world a better answer, so we've got to read on, but this is at least a candidate answer. And then D? We can stop right there, right? There are no words that could follow a recent public opinion survey that would make it an argument for the constitutionality of anything, right? Or anything like that, right? So think of that, not just that answer, which could never be a right answer, but other things that would suggest public opinion, a vote by anybody, really, right, is not going to have much to do with the constitutionality of anything, right? So then we find ourselves at C. Again, not necessarily the best argument imaginable for the constitutionality of the federal statute in question, which is presumably the 55-mile-per-hour speed limit, but at least is in the right territory. All right, so that's sort of a best answer kind of situation. All right, page 32 brings us to, in a way, an exception to the rule that was just articulated, although, of course, it's not a complete exception, and that is the Commerce Clause. That is the Interstate Commerce Clause, because we've got the Interstate Commerce Clause on the one hand and the Dormant Commerce Clause on the other. So the Interstate Commerce Clause is probably the primary justification for most congressional legislation in real life, and also on the bar exam. I mean, who knows, statistically speaking, right? I have not done that survey, but when Congress is legislating in an ordinary fashion, in any way that has to do with commercial activity, typically the source of their power is the Interstate Commerce Clause. There are many subtle and complex issues that have developed historically about what kind of commerce is interstate commerce, right? How much of an impact does it have to have on multiple states? Overhangs the market, these many subtle concepts that will allow many After all, virtually every commercial act happens in one state, right? And so how the Interstate Commerce Clause relates to the behavior of commercial actors, most of whose conduct may occur in a single state, but somehow be regulated by federal law. Those are the subtleties of the Interstate Commerce Clause. But that is not what you're going to be examined on. You're going to be examined on its big pieces, right, and the clearly established rules and principles that have been generated historically. So as our shaded portion notes, this is one area where Judge Spurious, or the less sophisticated question answerer, would get the answer right. He thinks the federal government can do pretty much anything it wants under the commerce power, and it's true, but again, even that's a slight overstatement, right? The federal government has tremendous regulatory power over commercial activity under the Interstate Commerce Clause. And so a situation the Interstate Commerce Clause won't reach will have to be very clearly articulated and hopefully easy to recognize. So let's take a look at question 2 on page 33. I'll read aloud.
Congress passes a law regulating wholesale retail prices of gas for every purchase or sale of oil, natural gas, and electric power made in the United States. The strongest argument for the constitutionality of this statute.
Right. So again, as we see in question 1, which didn't have facts, but which we were able to sort of deductively figure out must be about the 55-mile-per-hour speed limit on federal highways. As with that question, you are not asked, is the statute constitutional? That is, you're not actually asked the ultimate yes or no question that the Supreme Court would be answering should the challenge reach the court. You're just typically asked strongest or weakest arguments, best or worst arguments, right? And so the idea is what's being evaluated is your ability to identify what the shape of the argument should be, not to predict what the outcome would be if the question is one the United States Supreme Court has not actually faced, right? That is, it would be silly to expect examinees to actually evaluate the constitutionality of a statute, unlike any one that the United States Supreme Court has ever examined. However, it is reasonable to expect you to understand what the arguments would be on each side, as what are the strongest, most on point, most relevant, most persuasive arguments on each side. And that's, again, often, not quite always, but often what you're asked to do. So, and then we'll take a look at the answers and I'll make a few more comments. So, begin at the top with A, because again, here we're pushed into the answers because what is the strongest argument? Now there, with the statute before you, you should be thinking Commerce Clause, right? That is, it's a regulatory statute about commerce. You should be thinking Commerce Clause. But for all you know, all of the answers are going to talk about the Commerce Clause in some way, and you're going to have to slice the bologna a little finer, but you don't know. So start with A.
A. The Constitution expressly empowers Congress to enact laws for the general welfare.
True or false? It is not true. It is not true. There is no provision of the Constitution that expressly empowers Congress to enact laws for the general welfare. And when they put language in quotes like this, they mean, is that language, that very language, in the Constitution? It isn't, right? So that couldn't be the right answer to any question, right? Because it's just not there. It's not in the Constitution. Go on.
Congress has the authority to regulate such products interstate transportation and importation from.
Good answer? Bad answer? Is it talking about the same subject matter as the statute in question?
No, it's really talking about products.
Right. This B is, I mean, maybe Congress does and maybe it doesn't have the authority to regulate surely it has the authority to regulate the interstate transportation of oil and natural gas, right? Its importation from abroad also, right? Because that has, the sort of international character, and it's not a leap to think Congress has that authority. But it wouldn't be that authority that's the source of this authority, right? That would be this, in a way, this answer is as irrelevant as saying Congress has the power to advise and consent on the appointment of whoever, Supreme Court justices. True, but not relevant, right? So there might be a world in which it's the best answer, but the other answers would have to be pretty bad, right? Because what it would really be implying is whatever the source of Congress's authority is to do that, it's the same as the source of its authority to do this, but that's a stretch, right? So it's not a very good answer, although we're not going to eliminate it the same way we eliminate A as a false statement of the law. Okay, go on.
C, Congress may regulate the prices of every purchase and sale of goods, services made in this contract.
Because?
Well, that term becomes taught to do it.
Right, it's that every purchase and sale that is what tells us this answer goes too far. So that one's out of the running, and now?
Several
Okay. Yeah, D is superior to B. So this inseverable aggregates concept, when I was first teaching this material for this purpose, there are a couple of questions that use that. That is not language from any U.S. Supreme Court decision that I could find. I did a search to try to figure out whether it is truly a technical term or term of art. It isn't, right? It's just the idea that if the conduct in question is the sort of thing which, taken in the aggregate, would have an effect in this particular case on interstate commerce, then it's the sort of thing that can be regulated, right? So it's an argument against the idea that a particular transaction, which is not an interstate transaction, should fall outside the regulatory power of Congress by saying, if every transaction of that kind is considered, right, will it impact interstate or foreign commerce? If the answer is yes, then it's within reach of the Commerce Clause. That's the concept. So you don't have to hang yourself up too much on the language if you had not encountered it before.
Yeah, I mean, that kind of jumped out at me when I read it, and I actually, because I saw that language, I immediately assumed it because I had never seen several
Right.
aggregates.
Right. So, but that's all it means. It's not meant to, I mean, it is not a technical term. It's not in quotes, right? It's not meant to be something that's in the U.S. Constitution or, you know, in some important opinion that you somehow don't remember having read. I looked it up because that's what I thought. I thought, is this in some opinion with which I'm unfamiliar? It isn't. So it's just a concept. You don't want to be scared off by the vocabulary. And again, how likely is it you're going to encounter it? Who knows, right? But you just don't want to be scared off by it. Okay? Now I'm going to ask you to pull question 18, which is on page 51, up, and we're going to look at it next, and then we'll return to it because it's here as an example of a couple of things. But it's another inseverable aggregates question, so I want to draw your attention to it. So this is question 18 on your page 51. Okay, can you read it? Okay.
Congress passed an act requiring that all owners,
Yeah, no, go ahead. Yeah, it's short.
Congress passed an act requiring that all owners of bicycles in the United States register separate bicycle registries. The purpose of the law is to provide reliable evidence of ownership to reduce bicycle theft. No fee is charged for registration, although no stolen bicycles are theft or resold by the fee in the same city as the bicycles are stolen. An increasing number of bicycles are being taken to cities in other states for resale. This act of Congress.
And notice this is really the same question as what would be the strongest argument for its unconstitutionality if we were to take out the yeses and nos. Okay? So now let's read through them and do the same kind of analysis. But you see the same thing, right? It's another statute that regulates, in a sense, transactions or events, right, that often will happen just within one state, will have no impact on interstate anything, but then we're given information that suggests it has this interstate dimension. If we consider all of it together, all of the bicycle thefts together, we see something that may be having some interstate effects. So now read through our answers.
A, yes, Congress has the power to regulate laws.
True or false? That's the same false answer we saw before, right? It's worded slightly differently, but it's basically the same false answer we saw before. Okay?
B, yes, Congress that the acceptable act is bicycle theft.
Good answer, bad answer?
My opinion is, I think it's that answer.
I mean, is your sense that this law is constitutional? Okay. And if you were generating an answer, why would you think it was unconstitutional? Without looking at their answers. I mean, if your sense is it's unconstitutional, why do you think that?
One, I don't think it affects. I think I go back to that Morrison case where it has no,
But look at the facts that we're given. Look at the interstate fact that we're given. An increasing number of bicycles are being taken to cities in other states for resale. Right? That's the commercial impact that they're asking us to assess. So now let's look at our no answers and see what we think. Okay? And then we'll read the other one and then we can talk about it. All right, so what do you think of our no answers? Not like, right. So this is partly here because of the strategic suggestion that 10th Amendment answers are rarely the right answer, right? But again, you don't want to just be applying it mechanically. You want to understand the underlying law, right? That rarely, right, is that going to be the basis of the unconstitutionality of any law that has the right kind of interstate impact, right? That states typically and historically have done it does not get us all the way to it being a matter reserved to the states under the 10th Amendment if we have other facts that bring it within the interstate commerce power, right? So the question is C a reason for its unconstitutionality, right? Is it that if most of a regulated transaction occurs within a state, the federal law that regulates it will be unconstitutional? That's incorrect, right? That's incorrect as a legal principle. That's not how it works, right? The determination of whether or not that Congress can constitutionally legislate in an area is not empirical in that way, right? That is, that the evidence that it does impact interstate commerce which is empirical, of course, but that's the evidence that matters. It's not countered by evidence that a lot of the times they aren't taken across state lines. I just think of, the Mann Act, right? Taking minors across state lines for immoral purposes, right? That most of the time that's not what happens wouldn't make the Mann Act unconstitutional, right? That is because and so that it has the interstate dimension means that even when the regulated transaction is often, maybe even most of the time, occurring within a single state, that doesn't mean it doesn't have the kind of impact on interstate commerce that allows the federal government to regulate constitutionally. Okay? Right. Correct. As long as there is an analysis of the right kind that connects it to interstate commerce, that is a comparatively unusual or small proportion of the regulated transactions, is irrelevant. That is, it doesn't make the law unconstitutional. Yeah. Right. Right. Right, as long as you can recognize that A, it does not reflect that. Right, so you have to know that you're not doing that because of A, right? You're doing it for reasons that are not exactly going to show up in the answer, and then the answer includes some of the reasoning for that. Well, sure, if it's not a fundamental due process kind of thing, right? It's just, and again, they will make that clear, right? That is, they're not going to choose a law that's in a complex, difficult area. They're going to do something like, on the one hand, bicycles, and on the other hand, the right to vote, right? I mean, they're not going to put you in some middle ground. That's why they picked an almost silly or trivial example. Yes? All right, now back to page 34, and you can kind of hang on to that. I mean, I don't know that we need to belabor it, right? When we get back to the 10th Amendment, I'll say, remember question 18, the 10th Amendment question? Okay. All right, on to page 34 and the Dormant Commerce Clause. So the Interstate Commerce Clause affirmatively empowers Congress to pass laws that have the right kind of connection or impact on interstate commerce, as we have seen. The so-called Dormant Commerce Clause, which is an implied from the constitutional language, prohibits states from imposing an undue burden on interstate commerce. So the focus of the Dormant Commerce Clause is the limit of how difficult a state can make it for out-of-staters to do business in their state. It's not that they can't impose any regulations that in any way make it difficult for out-of-staters. But if it reaches the point of being an undue burden on out-of-staters, then that's where we're triggering the Dormant Commerce Clause. So the easy part to keep in mind is that it will always be a federal law enacted by Congress that implicates the Interstate Commerce Clause. And it will always be a state law that triggers a Dormant Commerce Clause evaluation. And so that's sort of the first big piece. And then we have the exceptions. The state may interfere with interstate commerce, and we have 3. So, I mean, I would convert these into a bulleted list or number them or something like that. Acting as a market participant, that is, the state is not acting in its sovereign authority, the state is a market actor. Acting in the least restrictive manner possible to address an important state interest, and that's often going to be picked up or triggered by licensing schemes of various kinds, right? The state requires a license to do something, and out-of-staters who might have a license in their home state still have to get another license. But the idea would be, is that the least restrictive way to ensure that everyone who is engaging in the licensed conduct knows what they're doing, and that will generally be okay. Licensing schemes are generally okay. Or acting pursuant to federal authorization. That is true and matters in the real world, but it would make for such an easy question, you're unlikely to see it, right? You're unlikely to see a question that says, Congress explicitly authorizes states to do X. A state does X. Is that unconstitutional? Yeah, no, right? But unfortunately, you're unlikely to see a question with that structure. Okay? All right, question number 3. Yeah. So that's going to tell you, right, a state statute. So it could be lots of things. It could be equal protection. It could be all kinds of things, but it's not likely to be the Interstate Commerce Clause. Okay, go on. Now, is that sort of law in general okay? I mean, if you were just analyzing the law in general without knowing what question was going to be asked about it, I mean, is that kind of law okay? Can states do that? Why can't states do that? Well, that's going to be the basis of the challenge. But is there any reason to think that a state can't require that all buses have seat belts? And do they? Right, so this is easy. I mean, again, this is not supposed to be a close call as to whether or not a state can do this kind of thing, because a state has general welfare powers that Congress does not have, right? That's part of what's going on here, right? It's the state level. The state can do things just because it thinks they're a good idea. I mean, that's a slight overstatement, but you take the point. That is, if it is the legislative judgment of a state that it would be in the best interests of everyone in the state to fluoridate the water, require seat belts, prohibit talking on cell phones in the car, right? They can do that. Now, we'll go on to see what's going to be the basis of the challenge, right? But generally, states have this power, whether we think of it as a general police power or power to act for the general welfare of their citizens, etc., that falls within the legitimate authority of the state. Okay, go on. Transport lines, right. Right, so their argument will be, Nobody else requires us. Okay. No other state requires us to have these seatbelts, so we haven't installed them on our buses. We don't even stop in your state, maybe, right? We pass through your state on our way between state A and state B, neither of which require seatbelts. But now, apparently, either we have to install seatbelts because we're going to be passing through your state, or we're going to have to take this other route, which is twice as long and is going to raise our gas costs, and we're going to have to raise our ticket prices. Again, we don't even exactly do business in your state, right? We don't sell tickets in your state. We don't have a stop in your state. You can't make us install seatbelts, okay? What's the best basis for their challenge? For their challenge, this is not about are they going to win, are they not going to win, right? What is the basis for their challenge? So now let's read our way through the answers. Good answer, bad answer? Right. Not that kind of thing, right? B? Right. Again, not the right kind of thing. Okay, go on. Maybe, right, if you sort of recognize this is a Dormant Commerce Clause situation, so maybe that's their best argument. And then finally, irrelevant, right, so they make it easy, right? We have a good candidate. It might not be the very best possible candidate, although it's pretty good, right, even if we think in the end it's not a winner, right? You're not asked here, is the law constitutional or not, right? What we're asked is, what is the argument going to be about? And what the argument's going to be about is, does this place an undue burden on interstate commerce? Meaning, does this make things unduly difficult for the out-of-state common carriers who are now going to have this regulation imposed upon them, right? Is there a good enough reason, right? Is that burden appropriate in light of the aims that it carries out? Or alternatively, is it an undue burden? I mean, this would not be a good example. This is, I think, a perfectly appropriate burden. Is it something that the state has enacted basically to make it impossible for out-of-staters to do business there, right? That is it really a secret scheme, right, which is intended to make it so burdensome or so expensive that out-of-staters just don't bother to do business there? That's what's not allowed, right? From a general, we're one nation and we're all in it together, right? And so again, the regulations can impose burdens on out-of-staters that may be inconvenient to some degree, but if they're justified, that's okay. If they really are just an attempt to make things very difficult for out-of-staters, right, that's different. Well, it may not be as narrowly tailored as it could possibly be. I mean, imagine that they could show that they don't have seat belts, but they have airbags, and the data indicates that airbags are just as safe, or maybe safer in the event of a collision for buses, right? So that's why they've installed airbags rather than seat belts, because people don't wear the seat belts or the airbags. You can imagine how to fill this in. That would come into the analysis of whether this has placed an undue burden, right? Because they would say, it's a belt and suspenders, right? Our buses are already every bit as safe as the buses that you allow in your state. We just haven't complied with your particular regulation. We would be having that discussion. Right, and so it surely is not the least restrictive means necessary. I mean, and again, if we're trying to think of what would be the kinds of factors, if the only factory in the country that, let's say they require seat belts that conform to certain standards, not just seat belts, but seat belts that conform to certain standards, and lo and behold, the only manufacturer of those kinds of seat belts is an in-state company. That's a little bit different, right? Then what they're really trying to do is make everybody buy these seatbelts from this company or not be able to do business there. That's more suspicious than just some kind of safety regulation. Including, for example, if the state had, I mean, imagine falling within the ordinary state regulatory scheme, state highway speed limits, right, that are lower. I mean, again, we can use this same picture, right? The bus that travels from state A to state B, passing through a state in which it does not really do business. Imagine the speed limit is higher in its point of origin and its point of arrival than is allowed on the state highways of the state in between, right? Does that place an undue burden on them? No, although they'd really rather be able to go 75 like they can in state of origin and state of arrival, but surely the state is within, they're not unduly burdening interstate commerce by deciding the safest speed limit on their roads is 55, right? That's not an attempt to make things more difficult for bus companies that, pass through their state in the middle of the night, though it may in fact make things more difficult for those companies, right? So again, you're not going to be given the whole, you're not going to have the whole record, right, that you would have if this were actually being litigated. You just want to develop some intuitions about what are the sort of laws that are unlikely to be successfully challenged. And again, be aware of these question structures, right? This is actually not asking you, is it constitutional or not, but only sort of best arguments, worst arguments, that kind of structure. Okay? All right. On to question 4, which is now, right, going to take us towards what Congress can do and how to understand the general welfare. That is what Congress can do for the sake of the general welfare. And what they can do is tax and spend, right? They can't regulate for the general welfare. They can tax and spend for the general welfare, but they can't regulate in a more general way for the general welfare. And so that's, you want to be paying attention when you're evaluating a regulation or a piece of legislation. Does it fall within this taxing and spending for the general welfare or not? Right? And this is both to recognize wrong answers and, as a matter of strategy, and also to be able to undertake the analysis in a substantive way. Question 4. All right, so again, the question would now be phrased, and maybe you'd have some other facts to distract you to some degree, right? It's, is it constitutional? Or what would be the best argument for the constitutionality of the statute? So Congress passes a statute that says you can't hunt them, or you can hunt them, or whatever it is, right? Best argument for the constitutionality of this statute would be, right, and now we're going to look through our various answers. So just at the level of an intuition, when we've got one sentence we're looking at, is your sense that this is constitutional or not? Because? Right, so now we're going to go looking for that in our answer, although we can also evaluate other answers. So start at the top. Right? Good or bad answer? Right, so bad reason. Okay, go on. Okay. Right. Right, and that's a sort of don't be distracted, right? That is, the regulation is about what's going on underlying federal lands, and the power of the federal government to regulate what goes on federal land is basically total, right? And so don't be distracted by the fact that the wild goose is itself not federal property. There's no claim that it is federal property. That is, the regulation is not a regulation that renders them federal property, right? It's about regulating the conduct of persons on the federal land with respect to, right? It's not like the regulation is telling the wild animals what to do, right? It's telling people what they can and cannot do with respect to the wild animals, okay? And then D. Right, so first of all, that has that bad, it's a 10th Amendment answer, right? So it's a bad answer. And then again, the federal lands thing is the thing to be paying attention to, really, more than the wild animals part, right? Right. And you might change, I made a note for myself in revising these materials. We have our little headlines here on pages 35 and 36. This is not a welfare state. And what it really should say is, nor is it a police state, right? So police power also, right? The federal government does not have a police power. Just as the federal government does not have a general welfare power, the federal government does not have a police power. The states do. The feds don't. And so that's why you need to be paying attention to who enacted the law in question, right? Because states have general welfare and police powers, but the federal government does not. It has this tax and spend power, which is very big. It has interstate commerce power, which is very big. But when we're looking for reasons, the reasons cannot derive from a power the federal government does not actually have, right? So sometimes it may be right answer, wrong reason, right? Again, as noted in our materials, unless the law concerns the District of Columbia, which it probably does not, right? I mean, that it could happen. It's just to make sure you have a correct statement of the law. There is a place where the federal government has police power, the District of Columbia, right? But likelihood of your encountering it, very low. Okay, question 5.
The strongest constitutional basis for the enactment of the federal statute requiring college and university to receive federal funds to offer solely on the basis of
All right, so now we're going to look through the various powers, right, because of the way the question is set up. Take us through them. Right, that's the distracting, tempting answer, that it's a law that regulates stuff, general police power, but the federal government doesn't have it. Go on. Right, irrelevant. Right.
And D, power to enforce the privileges and immunity clause of the 14th Amendment. That was really C.
Right. Also very unlikely to be a right answer, because privileges and immunities law is a actually quite underdeveloped area of the law. When you just read it as a layperson or as a law student, you might think it ought to be more relevant than it is, but it isn't very relevant, and so it's typically not a right answer. This is a question as straightforward as this is really evaluating whether you know this tax and spend. And a harder question would include other closer ways of framing that power, or force you to think harder, right, about how funding things is a way of exercising tax and spend. What are they doing exactly, right? When they're taxing and spending, this is spending, right? Spending for the general welfare by providing federal student aid, and that then enables them to attach conditions to it, because after all, the states could choose not to give that federal financial aid. Right, so it's not forcing the states to do something, right? It's sort of a benefit. It's a spending benefit to the state in the sense that it makes it possible for students to attend schools in their state, and hence the federal government can condition that aid, right? It's as much a form of aid to the universities as it is to the students themselves. And now a little more federal lands type question on page 37, number 6. Yeah. Yeah, well, this is longish, so let's look down and then we can think about the way the question might be framed today. So, okay, so that's the law that we're going to be talking about, right? Even without reading the facts. This may be one that's possible to answer without reading the facts, just because so much of the relevant facts have been put into this part, right? We're going to have a law, right, that forbids the hunting of wild animals that wander off federal property. So, at a glance, and again, we're not being asked, is it constitutional? We're being asked, what is the best argument for its constitutionality, right? Not that that argument will necessarily be a winner. It might not. Is your sense that such a law is constitutional? It's not the question asked. I'm just sort of, what is your sense? On what basis? I mean, imagine you are a hunter in a state where this is popular. I mean, in this moment of Duck Dynasty, I don't even know where they live. We're supposed to live. They live in Louisiana. All right, so they say, fine, we will not go onto federal lands and shoot ducks. But when the duck is off the federal land flying around, it's fair game, because literally fair game, because Louisiana, I have a hunting license, right? It allows me to hunt X number of ducks a year. There he is, he's flying around. How can I possibly be in violation of federal law? I'm not in the federal park shooting this duck. So how is someone supposed to know it even came from? Right, so you can see what the basis of the challenges would be. Now, what is the argument you would make on behalf of the Federal Bureau of Land Management, the federal government, if they had such a law? Yes, yes, yeah. What is, I mean, again, whether this argument would be a winner or not, what do you think is the best argument that they could make in response to the challenge that we've just articulated? I have a hunting license granted to me by Louisiana. here I am, I'm shooting the duck, right? How can I possibly be violating federal law when I do that? Yeah, I think the idea is you're trying to preserve these wetlands or wherever, right? Or this endangered species, or maybe it's not endangered, but it's protected in some way because federal endangered species law covers everything, right? So if it were actually an endangered species, you couldn't hunt it anywhere, even if you had a hunting license in the state. But the idea would presumably be something like, look, the animals don't know when they're in the park and when they're not, especially birds, right? So it's like you can have fences, right? So fences might cover a deer, the deer jumps the fence, whatever, but you could say it's on the Federal Bureau of Land Management to maintain those fences. You want to keep the deer in, build a fence that'll keep them in, right, or whatever. Birds, you know, they're coming and going. They're going to do what they want to do, but if like their nesting area is in the protected area, but they're flying around, if they are fair game to be shot as soon as they're on the wrong side of the fence, it won't be long before there will be none of those birds, right? Because then no one is taking care of the nestlings and whatever. I mean, you sort of see where this goes. And since you can't control them, if part of the purpose of this is the protection of these animals, right, this is the best argument. Would this argument be a winner? And maybe it would also depend on whether they actually are distinctive, right? Can you actually tell the difference between the ducks that are in the protected area? So look, you say, look, that kind of duck only, right, lives, and it has its nesting area here, and the kind of ducks you're supposed to be hunting are a different kind of ducks, and the duck hunter can be charged with that knowledge. And what, again, is that argument ultimately a winner? I don't know, not an area of my expertise, but you sort of see the lines along which the argument would run, right? So now, strongest argument for forbidding it, the strongest argument for its constitutionality is going to have to run in some way along these lines. Again, even if the argument is ultimately not a winner, because that you're not asked about. So now let's take a look. Good answer, bad answer? Yeah, it's not a great answer, because what's the property? Is it the animals? Is it the parkland? Well, or the other way around, right? This property exists for the protection of these animals, right? So we might be able to imagine a better answer, but it's not one we can eliminate as just false under all circumstances. Go on. No, wrong analysis, right? Right, so that's like when you see the words, the police powers of the federal government, you stop right there, because nothing that comes after that could possibly be right. I mean, it's true, right? If what we were considering was something like a licensing scheme, that might be relevant, but now in choosing between A and D, yes, A is our better answer, right? So Congress has the power to regulate and protect federal property, and again, that's kind of loosely understood. It's not requiring us to take a side on whether those ducks are themselves the federal property or not, right? Again, you're not going to be asked to choose between very fine-grained answers, right, that are making subtle distinctions between how this law would operate. As you can see, what you're given is an arguably correct answer and then a bunch of stuff that's more or less out of left field. Well, but here we already have the federal land, right? We can look back up into the facts if you want, right?
I just said, so just go off the federal land. That's
Yep.
what they go back.
Yep.
Is the verbiage privilege not a right always presumptively a
I'm not sure, because it might be about a licensing scheme of some kind, right? Or it might be a due process thing, right? Where you're being asked to evaluate whether something is a fundamental right or not, right? Like driving is the classic, right? The right to travel is a fundamental right, but you can still license drivers because it's the right to travel, not the driving that's the right. The driving is a privilege, right? So I would not necessarily rule it out. Not in the same way as some of the other things that we've been more ready to rule out. All right, on to page 37A and the Supremacy Clause. Quick rule, right? Federal law always supersedes competing state law. That's the Supremacy Clause. So in any area where federal law occupies the field, if there's a conflict with state law, the federal law trumps it. There are many subtle issues about when that is the case, right? That is in real life. There's lots of argument about whether a state law in an area that federal law also regulates has been now superseded by federal law or not, right? But you're not going to be asked to make those kinds of complex determinations. You're going to be asked to recognize situations in which the Supremacy Clause applies. There are also a couple little rules here, not very frequently tested, but you want to be aware of them because they're easy if you know them, and you can't reason your way to them. You just have to know. Here in the middle of 37A, if there's a conflict between a treaty and a federal statute, the last in time prevails. And even though executive agreements can cover the same subject matter as treaties do, treaties prevail over conflicting executive agreements. So you can draw yourself a little hierarchy or picture or something, and the Constitution is supreme where it applies. So some of these, the treaties and so forth and executive agreements may have to do with some international dimensions. Again, not stuff that tends to be very heavily tested on the MBE. Okay, number 7.
Evaluating the constitutionality of the state statute.
All right, so if you're told that much in the question, you may or may not have to read the facts, even though this is a short one, right? Because this is really, in a way, sort of a pure question of law, right? As you can imagine that this question is, in evaluating the constitutionality of any state statute under the Supremacy Clause, which of the following is most directly relevant, right? And that's a question you may be able to answer without even knowing what statute they're concerned with. Again, here it's short, right? So we'll look at the answers, then we'll look back to see if we need it, right? But we may not even need it. Again, it's short, so it's not like it's a waste of time to read it. Start with A.
A, the general unemployment rate.
Relevant or irrelevant? Yes. I mean, presumably the statute in question now is going to have something to do with employment, but statistics like that are not what's relevant to the Supremacy Clause. Okay, go on.
B, treaties and immigration laws of the United States.
Well, it might or might not be relevant, right? Because those might or might not be trumping some state statute, right? Again, without knowing what the statute is about. They are potentially relevant in a way that a piece of statistical data is never relevant, because they are potentially legally relevant, okay? Well, again, we don't know, right, having not looked at the facts at all, but those are federal laws, right? Treaties and immigration laws are federal laws. And whether, I mean, the underlying issue in the Supremacy Clause is it covering the same subject matter, right? And so if there's a federal law and a state law, we need to know what they are in order to figure out whether they're covering the same subject matter. But those are relevant. Answer C.
The need of the statute for this particular.
Need of the state.
Excuse me, the need of the state for this particular statute.
Relevant or irrelevant?
Well, that kind of goes to the interest of the state in regulating this particular.
But it doesn't matter. No matter how important it is to the state, if the feds have already occupied the field, the Supremacy Clause applies. And if they haven't, it doesn't. Right, this is really about the overlap between the state statute and some existing federal statute, and what is sometimes subtler, but which you're basically never going to be asked to do in the MBE, is there a real conflict between them, right? They're different, let's imagine. Does that mean there's a conflict, or does that mean they can both exist side by side? That's complicated, right? That people litigate about, right, in order to figure out whether the intent of the federal statute was actually to supersede any existing state statute, or whether the federal statute is setting a minimum and states are allowed to go further. Imagine, for example, an environmental law, right? So the state sets some emissions standards. Can the state go further, or can the state not go further, right? That's a question, right? Because they're regulating the same subject matter. But when the federal government set that emission standard, did they mean if states want to go further, they can, but they can't go less. They can't make it easier. That is, they can't relax these standards in order to invite the polluter in. But if they want to make it harder for the polluter, they surely can, right? Within the general welfare, the state has the right to say, we want air cleaner than the federal government requires, right? That's complicated, right? In figuring out whether the intent of the federal environmental regulation was to set a uniform standard across the country and not allow states to make it harder for out-of-state companies or polluters or whatever, or to do something different. But the first level of determination is, are they regulating the same subject matter so that there's even a potential conflict, okay? And again, the need of the state, irrelevant. That's just like a pure empirical fact. It's not a legally relevant fact. And D?
The number of aliens currently residing in
Again, this is just an empirical fact, right? It's irrelevant. The question is there overlap of subject matter? And so the answer must be, right, it's the only one that's legally relevant. Now we can take a look at the statute if we want. Take a look at the statute. Go ahead and read from the top.
State of Utah provides by statute that a person may be awarded any state construction contract without agreeing to employ only citizens of the state and of the United States.
Right, so this is the statute by which, right, the state is maybe going further. Well, I mean, it is going further because if you can only employ citizens, you can't even employ legal permanent residents, right? You can't employ people who are here on, and again, it's not as if they're testing your substantive knowledge. That's the other thing. They're not testing your substantive knowledge of immigration law and how it works, right? And so that's the other clue, in a way, as to what is relevant, right, that helps us to see that this is the right answer. It's the treaties and immigration laws of the United States, whatever those are, right? It's not actually expecting you already to know what those are. It helps if you happen to know, for example, that there's such a thing as a work visa that an alien can get. Now, in that state, the alien with a proper HB1 visa wouldn't be able to work. The state would have prohibited it. The question is the federal government's creating the category of a work visa intended to prevent states from doing exactly this or not, right? That is a subtle question of immigration law that you are not going to be expected to answer in an MBE question. What you are expected to know is federal immigration law is federal law, and this is potentially in conflict with it, right? And so that's what you're expected to know. Again, not what an HB1 visa is, right? And whether it purports by its own terms to allow someone to work in any state, and thus the state preventing someone from hiring them would actually be interfering with the federal immigration scheme, which allows a certain number of persons to enter the United States for purposes of doing this, that, or the other kind of work. And this is an unfair discrimination against them in the judgment of the federal government, in which case that would be something the state is not allowed to do. It might or might not be true. I have no idea, and I actually know a little bit about visa law, and I have no idea whether this would be unconstitutional because of that. I don't know.
So the key to getting this answer right is essentially being able to quickly identify that the need of the state to answer choice C is irrelevant.
Right.
And the factual data points
Are irrelevant.
They're irrelevant.
Right,
The
that
only
A,
thing relevant is
exactly,
federal law.
correct, that A, C, and D are all about the facts. And the application of the supremacy clause is not about facts. I mean, it's not about facts in that sense, right? The only facts that is relevant is what is the subject matter area that the state law is regulating? And is there a federal law that regulates the same area? And that is in a way a factual determination, and in another way it isn't, right? That's the subtlety in real life. Right? But it's only the legal relationship of these laws to one another that's relevant, not why they have the law as a factual matter.
Because in the question stem, as soon as we see supremacy clause, we immediately know that it's going to be a conflict between state and federal law.
Correct.
So then we don't even need the facts.
Not really.
We really
Not really.
have to go down to the answer choices and say,
Right.
okay, what's the answer choice that deals with the conflict between
Right.
state and federal law?
Right.
And anything that's not relevant
To that.
conflict or overlap of two laws.
Yep, will be a wrong answer. And again, you will not be expected, I mean, the con law questions all have to also have a subject matter area, right? but it's not a subject matter area you'll be expected to know, right? And so anything that really gets you into the guts of the subject matter can't be something that they're expecting you to know, right? And so that's also, even if you happen to know it, right? All right, on to page 38. And this is the question. I've sent a note to Sherry about this because I think the correct answer may be a different one than is in my materials, but it's down to 2, so we'll be able to eliminate 2 of them, talk through the other 2, and then go from there. So starting at the top with the materials, the MBE will frequently challenge you to tell the difference between equal protection and due process. That is, there'll be both of them will appear in the answers. One of them will be rightatory in some way or burdensome in some way. It's burdening somebody in some way. And the STEM will ask you whether it will be struck down, and if so, under what provision. The 2 most common answers involve due process and equal protection. So your instincts and intuitions may be pretty well developed in this area. You'll have a sense it's unconstitutional, but then you'll have to answer why. Unconstitutional because of one reason or the other. The distinction can be made by asking whether the law affects a particular class of people or whether it affects everyone. So that is a way of thinking about it. If the law affects a class of people or creates a class of people, think equal protection, otherwise think due process. All right, so that's at least a first approximation. So let's start with, this has a lot of facts, so let's start with the question STEM itself.
Which of the following constitutional defenses to the prosecution
All right, so this is a logically hard way of setting up a question. What are we looking for? Glossed in another way, the defense is least likely to succeed, right? This is like a worst argument, which is just weird, right? It's weird to go looking for the worst, most irrelevant argument. It's something like that, right? And I think if you encounter that, it's worth like even writing yourself next to it, especially because you're going to have to go back and read worst argument, right? Or something like that, that you're looking for the worst one. For the best one. It's really hard, right? And it's hard even to evaluate if things are bad arguments, which is worse than the other one, right? If it's a bad argument, aren't all the bad arguments equally bad, right? It's like, how do you figure out which is the worst argument? So I think, again, that's also somewhat of a weird question structure, which may be part of what's causing me an issue in being clear about which one I think is really the worst. Because it could be that none of them are very good, or that some of them are good. 2 of them could be good, and 2 of them could be bad. We don't know. All right, so now let's evaluate the statute and then think about how to answer the question, because those are sort of 2 different things. They're related, but they're not identical. So take it. No, because they may all be wrong, right? Least likely to succeed means bad answer. You're going looking now for the bad answer. But what if they're all bad? How do you figure out which one's the worst? Yeah.
What really jumps out at me though is D, because.
But we're not there yet, but go ahead.
I was just going to say, when you see freedom of speech lined up against the 14th Amendment, that's a pretty tenuous connection. I mean, freedom of speech typically is associated with the First Amendment.
Yes. No, that helps. That helps in thinking it's a bad argument. But just wait and see how bad all of them are, because that's what right, that's what makes it difficult to find out which one's the worst. That would be great if the other 3 were really good, right? But if the other 3 are bad, how do we figure out which is the worst of a bad bunch? That's a hard thing to do. It's weird, right? All right, so let's take it from the top with the facts. Right.
John Doe, the owner of a milk container manufacturing firm, sought to focus public attention on the milk packaging law of the state of Clinton in order to have it repealed. On a weekday at 12 noon, delivered an excited, animated, and loud steps of the takeout.
Right, so you're sort of thinking, to the extent you know this is a constitutional law question at all, you're thinking First Amendment, time, place, and manner restriction. Is he violating some licensing scheme? Is he inciting a riot? Are these fighting words? Right, you're sort of thinking along those lines. Go on.
An audience of 200 onlookers gathered on the steps laughed at the tirade. Joe repeatedly stated, gesturing expressively and making faces that the damn law is stupid, and that I will strangle everyone on those goddamn legislators. I can get a hold of this law. They created treaties. They are all peace treaties for the rest. After about 15 minutes, Joe stopped speaking, and the new crowd
Okay. So he's kind of a crazy guy. He's delivered this harangue. There's no riot. It just occurred in the way that we've now heard about. Okay?
The state statute enacted in 1880 makes criminal the utterance in any public place of any blasphemy or practice. Assume that there have been only a few reported prosecutions under the 1880 statute. Joe's charged with violating its descriptions, charged with state forward on the speech delivered on the steps of the state capitol. The following constitutional defenses to this prosecution under 1880 statute would be likely to proceed.
Okay. So now let's read. Thinking worst argument. Worst argument. Right. Start with A.
A, this statute is vague and therefore violates the due process clause of the 14th Amendment.
Okay. Is this statute vague?
Yes.
Yeah, it's vague. So that's a good argument. So it's the wrong answer. Right? So you could put next to it good argument or cross it out or something. Because seriously, you can like lose track of what you're looking for while you're reading these. You're like, who's saying this? Is it a good reason? Is it a bad reason? So that's a good argument, and let's not think about it anymore, because that's one of the first arguments his lawyer should make. This statute is vague and overbroad and unconstitutional.
Yeah, and good argument.
Yep.
This statute, B, this statute is an establishment of religion and therefore violates the due process clause of the 14th Amendment. Establishment of religion. Person.
Okay. Right?
Yeah,
Right. So do you think this statute is an establishment of religion?
no.
No? Not at all?
Oh, I'm sorry.
Yeah, you see right, right. So it's hard. Is this a good argument? Is it a bad argument? I mean, it's okay. It's not a great argument like argument A, right? So it kind of depends whether what's coming are better arguments or worse arguments, right? Okay, go on.
C, application of this statute to Joe denies equal protection of laws and violation of the 14th Amendment.
Is this equal protection at all?
No, this one affects everybody.
Right, so I think that's a bad argument, right? So it might be the right answer. That's a bad argument because this is not an equal protection, right? That is the way he is burdened, if at all, is the due process way, right? That is, it's a fundamental liberty interest, right? Also protected by the First Amendment that's being burdened, right? Yeah, I know. Well, and you hope that you'll have few of them because they're like so logically complex, and it's not, even when they're not legally complex, they're logically complex, and that's like a whole other level, okay? So that's a bad argument. So possibly the right answer, right? Okay, and D?
D, application of this statute to Joe denies him freedom of speech in violation of the 14th Amendment. Again, free speech doesn't violate the 14th.
Well, but that's going to get you nowhere. As you notice, every one of these answers is a 14th Amendment answer, every one.
Right.
Right? So figuring out which is the worst one, we're not going to be able to do it by that means. Right? So what do we think is the worst argument here? Right. I mean, I think A and D are both okay. They're at least in the right ballpark.
Oh, because
One is about free speech, one is about vagueness, right? Those are good enough to not be the worst one, right? The question is, which is worse as between B or C? And here, we will not belabor it for too long. This is the one about which I have an outstanding question to her, because I think C is worse than B, but it's not what's in the materials right now.
Aspect of the 14th Amendment that
Well, any rights, right? I mean, the problem is B and C are, well, equally bad, equally good. That's the problem. I mean, I take the point that the connection between religion and the 14th Amendment is worse legally, right? On the other hand, this is less an equal protection issue than it is an establishment of religion issue, right? And so as between B and C, it's really hard for me to see how you're supposed to figure out which one is worse, right? Because if the issue is this more about burdening a fundamental right than it is about equal protection? I think the answer is clearly yes. This is not about equal protection, not at all. And that suggests to me that C is a worse answer. If you look at the subject matter, right, vagueness, establishment of religion, and freedom of speech are what this is about. Equal protection is not what this is about. And so I would argue that C is the worst answer for that reason, because it's the least relevant. But I think you're right in saying that of all of these, the least connected to the 14th Amendment might be B. Right? How would you, who knows? I mean, and of course you're not going to encounter this exact question. So the idea is to be sensitive to the right strategic approach for a least likely, which is just really a logically incredibly challenging question. They say B. They say B. I say C. I mean, I'll say it, whatever. It seems to me C is even worse because it's not legally relevant in the right way.
I agree with you.
Yeah, so I'm not totally persuaded about it. I need to hear more, and so that's why I have a question. If she may be able to come back to me with more that will then satisfy me as to why B is even worse.
Well, the state statute prescribes speech, okay? And so obviously the worst answer choice would be something that didn't even deal with that
speech.
fundamental right.
Correct. Hence, that's my reasoning. Okay? All right, so again, we don't need to spend too long on it. Let's turn to page 39. Yes. 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 So the distinction that we're reminded of here is the 5th versus the 14th Amendment. Federal action is regulated by the 5th Amendment. The 14th Amendment incorporates against the states. Right? So it is possible that you will be tested on that. Right? That the 5th Amendment has to do with what the federal government can do, that the 14th Amendment incorporates against the states. Right? So the reminder here is if you think a statute is justified or invalidated, right, either way by the Equal Protection Clause, make sure you do not just pick the first answer that mentions it, because you might have to be distinguishing between the 5th and the 14th Amendment. All right, number 9. All right, so here's another one where we're being given a question without the facts, right? So we're going to have to read in order to get some sense of it, right? But we've got a federal court acting, right? We'll be able to generate the statute by working backwards, right, as we read through the answers, looking for the right elements. Okay? Okay, might be true. We don't know. We don't have any facts, right? True or false? Right, so that's the example of the answer that can't be right. Well, we're in federal district court. There's sort of an allusion here to abstention doctrine, which I do not think is heavily examined, right? But what's being suggested, right, that a constitutional issue should be litigated first in state court doesn't make sense, right? So there's some issues, right, where various elements of federal abstention doctrine might be triggered, but not the constitutionality of a law. Right, that is, the U.S. constitutionality of a law is a federal question. It's like the classic federal question. And? I mean, again, we don't have our facts, right? So we're struggling a little bit, to imagine. But it looks as if what the Bar Association is discriminatory, supporting segregation in some way, itself is practicing segregation or exclusion on the basis of race or something like that. I think that's the idea, right? So we have a state-supported organization that's engaged in some actions in support of or that are themselves racially discriminatory. It's challenged in federal court. All right, so is there a federal claim? The federal claim is the constitutionality or otherwise of their activity or regulation or rule, right? And that some Bar Association activities are within the domain of state law, of course, does not, as a matter of the law of federal jurisdiction, prevent a federal court from hearing it. So this is a little bit 14th versus 5th Amendment in terms of eliminating a wrong answer choice, and a little bit just remembering the law of federal jurisdiction, right? And federal question jurisdiction and when it exists. But again, it's not like it's some close question. You'll have to be given some close question of federal jurisdiction. This is the claim that the state practice violates the U.S. Constitution, right? So it's not, again, it's not going to be, not a close call. Well, that's, again, one of those overstatement, right, overstatement type answers.
Right, so you can say, just based on the word solely,
It's probably wrong.
it's presumptively wrong because
Yes.
that's overbroad statement.
Yes.
So then that leaves us, we dismissed B, so that leaves
Right.
us with A.
Yep, and that's it, right? All the rest are just bad answers.
C was bad because abstention doctrine is not really relevant.
Right. First of all, it's not heavily tested. It has a lot of subtleties in it, and so they're unlikely to be the kinds of things that you would be expected to know. And then bad reason, right? That is, there might be good reasons for abstention, but that's not one of them, right? And so even if you know abstention doctrine or vaguely remember anything about abstention doctrine, it would be, I mean, imagine it was a state constitutional provision or something like that. Then you might think, oh, maybe this is the thing where the federal court's supposed to abstain, but not under these circumstances. So our next question we're going to do at the same time that we fill in the little frolic and detour chart on constitutional standards. So this is question 10. Question 10, the way it has been presented to us, it's being made easy in a way, right? That is, if you actually saw this question, you would probably have an entire column full of facts that include this state statutory funding formula for we have no idea what, right? It's just a state statutory funding formula for something or other, right? And the question here is about standards of review, right? Which of the following best describes the appropriate standard by which the court should review the constitutionality of the state statutory funding formula? So again, are you likely to encounter a question like this? I don't know. It is of that, which of the following is most correct, right? Style that forces you to read all of the answers, which they have moved away from. It may be the kind of question which allows you to eliminate answers because they are simply wrong statements of the law. And the way that something is going to be a wrong statement of the law is by a mismatch between the standard of review and then the terminology that's used, right? So if there's strict scrutiny language, but it's called rational basis, or they're mixed up in some way. So when those who prepared our materials say you have to memorize, what's meant is you have to memorize the words of the standard of review at each level so that you will recognize a mismatch. Right? That is, you have to recognize what words are used when strict scrutiny is appropriate, when intermediate scrutiny is appropriate, or when rational basis review is appropriate. And it's a good idea to keep in mind the kind of rights being implicated in each of these cases so that you can match up the appropriate standard of review with the category or class of persons or subject matter being regulated in some way. So let's look first at the table, and then we'll look at question 10. So this chart has set it up in such a way that due process and equal protection are both here, but we'll start in the middle with intermediate scrutiny, which does not have a due process counterpart. There is no such thing, at least officially speaking, as intermediate scrutiny for due process, which is to say for the burdening of fundamental rights. Right? That is, if a fundamental right is burdened in the due process fashion, it receives strict scrutiny, and if the right is not fundamental, rational basis scrutiny. There is no intermediate category. There is an intermediate standard of review in the equal protection analysis. When is that standard of review appropriate? Yes, so I would sort of add a fourth, I mean, I don't know if when applied, if that's where it goes, right? It's for, and it's kind of gender and everything related to it, right? So legitimate regulations that affect extramarital children differently than marital children, right, are also in that category. But gender is certainly the best known.
What about transgender issues?
If it's anywhere, it would be there, right? But again, that would be like such an outlier question at this stage, given the multi-year process of question review. Unlikely that it's yet going to show up, and that it would show up in a way that required you to select a right answer, as opposed to discussing whether which one or another of these standards ought to apply, for example, in an essay question. Strict scrutiny, working just on this when the law is applied, what are the sorts of fundamental rights that are that are entitled to strict scrutiny in the fundamental due process setting? Another way to put this is, what are the fundamental rights from a due process point of view? Yes, voting, travel, and then the privacy cluster, right? So, yeah, marriage, procreation, contraception, right. The family, maybe would be a way to put a gloss on it, but we want to be careful about that. And then in the equal protection context, which are the classes that are suspect and hence entitled to the highest level of scrutiny? Race is the big one, and then sort of the race-like, right? Alienage, ethnicity, national origin, right? Those are the easy ones. What kind of situation? What? Yeah, I think that counts as fundamental, sort of in family. It's more about the family right in a way than it is, I think, about the educational right. And then rational basis is, of course, everything else, right? So it's not like we really want to itemize down here in rational basis. It's everything else. And you want to be aware of things, I mean, to the extent that we want to identify particular rights or particular classes, the reason we would put them there is to remind us that they don't go somewhere else, right? It's not as if they're going to be exhaustive, because rational basis is everything else. That is, the default is rational basis analysis. And the burden of proof is on anyone who thinks that the classification is one or the right is one which is entitled to a heightened level of scrutiny. Now, this is we start at rational basis, and the burden is to move it off of there. So, non-fundamental rights include, for example, a right, in quotes, to education and other rights that might be burdened, right? But even when they are burdened, the analysis we apply to that is not the heightened scrutiny of strict scrutiny, but rather the rational basis review. And similarly, classes that are not suspect classes, right, even in the intermediate fashion, almost every law that burdens anyone, or one way a law that burdens anyone may operate, is to create classes of persons. But if those classes are not any of the protected classes, then we apply rational basis review and nothing else, right? And it's easy for laws to be justified that way. That is part of the point of trying to apply a heightened standard, is to make it harder for the law to be justified. Right? So examples of classes not entitled to any special protection at the federal level include disability, age, wealth, which is to say poverty, right? So that things make it harder for groups of people doesn't mean they're entitled to any heightened scrutiny. They have to be scrutinized, they have to withstand rational basis review, but they're not entitled to any heightened scrutiny unless the class itself is protected in some way, is a suspect class in some way. Okay? So once you show that strict scrutiny applies, the burden will now be on the government to justify it in accordance with the standard we will articulate in a moment. Same thing goes for intermediate scrutiny. Yes, in both cases. In both cases. Once the standard of review is heightened, the burden shifts. So for rational basis review, the burden is on the challenger to show that the law does not even, right, withstand the rational basis review. So now we want to make sure that, so now what we've discussed so far, you need to know. I wouldn't exactly say memorize. You should know and understand it. The tests have to be memorized so that you recognize their keywords when they appear. So again, we will start at the bottom, right? What must be shown in order for a law to withstand rational basis review? That the law is rationally related to a legitimate government purpose. And that's a very low standard, because rationally related doesn't have to mean it was what they had in mind. Right? If you can come up with any rational basis for the law that relates it to a legitimate government purpose, it will survive this kind of review. And very rarely is a legislature going to, or Congress going to pass a law that is not rationally related to a legitimate government purpose. Right? Whatever might be argued, all the ordinary run of laws are going to satisfy this standard. Yes? Right, and the law duly enacted is presumptively valid. Right? The burden is on the challenger to show it doesn't even have a rational basis. If the challenger persuades the court that intermediate scrutiny applies because a suspect class, a quasi-suspect class, for example, gender, is involved, right? Then the standard is substantially related, not just rationally, substantially related to an important government purpose, right? So both are heightened, right? The degree of relationship and the importance of the purpose are both heightened. And then finally, for strict scrutiny, the law must be necessary, right? So a still higher standard of relation to achieve a compelling government interest, also heightened. Now, it's not like we're going to have some extremely clear black letter definition of the difference between important and compelling. They might show up as synonyms in a thesaurus, but they're not synonyms in constitutional law. Right? Compelling is supposed to mean more than just important. Because keep in mind that what we're doing is singling out for discriminatory treatment either a group of persons, or we are meaningfully burdening the exercise of a fundamental right. And the idea of strict scrutiny is not that the government can never do that. The government can do it, but only if it is necessary to achieve an important government purpose. Right? And not simply because it might be rationally related to some legitimate purpose, etc. Okay? So that you need to make sure you have pretty vividly before your mind so that you can recognize it. Once you do, the questions are not going to be incredibly hard. They're not going to ask you to speculate in areas of law heretofore undecided, etc. But merely mostly to recognize the operation of the tests and the circumstances in which those tests will operate. So, question 10. All right, so we don't know what this is a funding formula for, so we're going to have to read and go looking. Okay? Stop right there. Stop right there, because, correct, cross it out. Stop right there. Right, because, correct, correct. Cross it out. Go on. Because? That's right. Again, without knowing whether there is a fundamental right or suspect class, right? Right, because correct, if gender or race are the class, this won't be the right answer, even though it will be a true statement of the law, because it will be a false characterization of the law in question. But without knowing that, this one is at least a contender. Okay? Right, this is the intermediate scrutiny test, right? And yet the facts look like, is it going to be race? Is it going to be wealth? Right, but it doesn't look like it's going to be anything that has anything to do with gender. Now that's not completely impossible, right? It's not that we couldn't imagine cooking up some facts that might make this the right answer, right, for intermediate scrutiny, but without more, C is going to be our superior answer. Right, which looks like it's going to have some kind of disparate impact on poorer districts, maybe, right? I mean, we can imagine a state statutory funding formula that bases how much money the schools get on the property taxes paid in that district. And that will then make districts that have lots of rich homeowners get a lot of money, and districts that have not very many rich people or homeowners get almost nothing, right? That would be I mean, I think that's the kind of law that we're thinking about here, maybe, right? And then when we look at D, we see D is really another way of articulating A, and it's just as wrong, right? So I think probably that would be what those facts probably look like there, right? Yes. Our next one, question 11, is, I mean, as the editors of our materials put it, the phantom fundamental right. And that really is about knowing what the fundamental rights are and what they're not, and not being seduced, right, or careless in your reading about whether a right is or isn't fundamental. There are lots of things, the way I would put it is, there are lots of things that we might think ought to be fundamental rights, right, that are subjected to the same level of scrutiny in the event that they are burdened. But if they have not been recognized as such, you're out of luck at this stage, right? And so in answering the question, you want to be sure you can recognize them or not, recognize when they're present and when they're absent, and go from there. So start with 11, read the question first, and then we'll double back. And it should be statute. There's a typo there. Yes. All right, so this is going to be someone challenging a statute, but we have no idea what this statute is about. Again, today, some of those facts will be dragged down into the question, so let's go up, and then we can also rephrase the question a little bit. Okay, so this is about inheritance, right? This is a gloss on the facts of an actual case. Do you know this case? I mean, I know this case because I teach this material. This is a gloss on the facts of a case called Trimble against Gordon, which is a 1977 United States Supreme Court case, which made the absolute exclusion of non-marital children from the scheme of intestate succession unconstitutional. So from 1977 forward, non-marital children cannot be completely excluded. Right? They do not have to take they can be subjected to additional burdens of proof, but they have to be burdens they could actually meet, right? And so the idea is if the child has to be acknowledged once the father is dead, that's a standard you could never meet, right? Even if you can prove you're this person's child, he can't acknowledge you now, and so if he never acknowledged you during life, you'd be totally excluded. A law that totally excludes a child in that situation is unconstitutional since Trimble against Gordon. But you don't have to have read Trimble against Gordon in order to know how to answer this question, right? here's the statute. It's excluding non-marital children totally, right? You might think that this is roughly in the intermediate scrutiny area, but that may or may not show up in the answer. Just because it sort of is like sex and sexual privacy and the non-marital child, although status, right, and legitimacy, right, we don't know. So we're going to have to go looking in our answers. Well, because it's not about, I mean, we're viewing this from the point of view of the child, and for all we know, the illegitimate child, not the term I would, the non-marital child, is richer than his parent, right? So it's not that this is showing, it's not creating, the class it is creating is the class of unacknowledged illegitimate children, unacknowledged non-marital children. And so the question is that class entitled to a heightened degree of scrutiny, the non-marital children? And if so, I mean, it seems to me, and again, it's because the law relating to intermediate scrutiny was actually developing at the same time as Trimble against Gordon, right? So it's not, right, it's contemporaneous with that. It wasn't the way Trimble against Gordon itself was argued, because there was no intermediate scrutiny really as established at that time. But we've got to go looking in the answers to see whether we're going to have to make that fine a distinction or not. So let's start working through our answers.
So A, there is no rational basis for preferring as heirs collateral relatives and even the state over unacknowledged children, and therefore the law violates the equal protection clause.
Right, so that is a strong argument if you can make it, because it's always the strongest argument to show it doesn't even satisfy rational basis. Right? Because a law that can't survive rational basis review can't survive any kind of review. So that's a strong argument if he can make it. What we'll be looking for is whether there's something that's going to ask us to make a finer distinction, because this in some ways relates to sexual privacy or something like that, maybe tenuously. Okay, go on.
B, has been deprived of property without due process because of his fundamental right to inherit has been compromised without a compelling statement.
Correct. There is no right to inherit, as I say many, many times when I teach the Wills and Trust class. What there is, and this is, again, it's a more fine-grained point, but we'll double back to this when I teach you the law of wills and trusts. What there is, actually, is a fundamental right to dispose of your property at death, as you wish. But that's on the giving end, not on the receiving end. Right? So if the state, for example, were to wipe out both intestate succession and being able to devise property by will, some particular kind of property, that, under Hodel against Irving, which we'll talk about very briefly when I teach you the law of wills and trusts, that is an unconstitutional taking, right, and requires just compensation. That's a Fifth Amendment violation, right? So people have a fundamental right to dispose, right? Their fundamental right to property includes a fundamental right to dispose of it and pass it on at death. No right to be on the receiving end. All right, see? Yeah, this is one of those typically not right. If we can get in closer, it's very unlikely that would be right.
B, it is a denial of procedural due process because it does not seem to be unacknowledged but really valid opportunity to exert. I think A is a better answer.
Yeah, this is just not, it's not the right sort of category. And it's also internally wrong, right? Because this is a substantive rule. It's not right. It's not just deprivation of procedural due process. Right. Well, that's right. It wouldn't matter because he can't. It's not that he can't prove it procedurally. It's that he can't prove it substantively, right? Evidence won't be taken on the question, not because he doesn't have he has notice. He finds out about the probate proceeding, but he's not allowed to show that he is the child of so-and-so as a substantive matter, right? All right. And that, again, you just want to be familiar. There are different ways that something that might seem to be a fundamental right or that we might wish were a fundamental right will be implicated, and it isn't. So, again, this is just a quick recap here at the top of what I think is your page 43. Be aware of these fundamental rights. To travel, to vote, First Amendment rights, and then the privacy rights, the group of privacy rights. So that overlaps with the First Amendment. to which we can now turn our attention. And there are a lot of rules here, and you need to be familiar with them. They constitute typically between a quarter and a fifth of the constitutional law questions that will appear on the MBE. Sometimes overlapping, like as we saw with the blasphemy rule. So it's like a little bit of First Amendment question and a little bit something else. And then sometimes knowing standards of review relating to regulations, and sometimes ways of evaluating the constitutionality or otherwise of those regulations. So the first distinction that you want to be able to make in a careful and reliably correct way is a distinction between content-based regulations, which are usually invalid, and conduct-based regulations, which may be valid if they are content neutral. So the first determination that you need to make in looking at the challenged regulation is it content-based or content neutral? If it's content-based, it's almost certainly invalid. Right? Government cannot ban people talking about X, Y, or Z. On the other hand, if it's content neutral, but conduct-based, which is going to set us up for time, place, and manner restrictions, right? That's a whole different story, right? If they say you can't talk about X, Y, or Z on the steps of the courthouse between noon and 1, that's a whole different thing, right? That's got a little of each. And if they say no one can talk about anything at all, right? That is, there will be no public protests between 12 and 1, right? That's totally content neutral. So the conduct itself in the public forum, the time, place, and manner restriction, is permitted as long as the regulations are content neutral and narrowly tailored to further a significant government interest. But notice that the significant government interest can just be the ordinary conduct of business in a government building. Right, a time, place, and manner restriction that's not excessively burdensome is perfectly okay, right? That's narrowly tailored to the significant government interest, right, of operating the building without too much disturbance. Again, as noted in our materials, the government can regulate speech more broadly in non-public forums not historically linked to speech. Our example is the military base. And here, the regulations must be viewpoint neutral and reasonably related to a legitimate government purpose. And then any restrictions based solely on content must be narrowly tailored to achieve a compelling government interest. And I think the next sentence is a little bit potentially misleading or confusingly phrased, that such an interest is found in unprotected speech. It's not that the interest is found in unprotected speech, it's that the interest is found in deterring or regulating or banning that speech. Right? That is, the most unprotected speech is the speech that can be regulated the most, even in terms of content. And there you want to be familiar with the various categories: obscenity, fighting words, language that incites imminent violence, false commercial speech. Right? This is the kind of speech that is not protected and hence can be regulated based on its content. And I think false commercial speech is an interesting one to remember. I mean, we often think more readily of fighting words or obscenity, right? But I think a good way to remember this rule is to think about what is the basis on which the government can ban or heavily regulate false commercial speech. Right? Why doesn't it violate someone's First Amendment rights to say this, to prevent them from saying this drug cures cancer when it doesn't? Right? Because that's unprotected speech, right? That speech whose content the government can regulate. That is, the government can constitutionally say you cannot make claims about the medical efficacy of a drug or a food or whatever unless it's been proved in the following way. Well, it's not commercial speech. Well, but that makes it, oh no, but that's completely different because any politically relevant speech is the most protected speech, right? Even if, I mean, it's in the sense that it's almost allowed to be false, right? Because it's the core, right? That is, political speech is actually core First Amendment speech. It's the most protected. And so, in a way, paradoxically, the least regulated and the least able to be regulated, right? I mean, if someone actually defames you, of course you can sue them, but there's a high standard there, right? Because the idea is we want the maximum range of options and facts and so forth to come forth in the political sphere, which is completely different from turmeric cures cancer or whatever, right? That is, there's no interest whatever in being lax in allowing claims of medical efficacy made about, unproved claims of medical efficacy. They do not improve our polity. But the idea is political speech, almost anything that's said, potentially is valuable and and improves our polity and our political process. And so that's the most protected, even though it does seem to have, I mean, it's not commercial, but it seems to have that kind of, right, how is buy Coke different from vote for X? Well, from First Amendment point of view, totally different, right? That is, you can't say about Coca-Cola things that have not been appropriately approved and regulated, and that whole regulatory process, which can take years, doesn't violate anybody's First Amendment rights. Right? You don't have, in that sense, a First Amendment right to say just anything you want about goods you're placing into the stream of commerce, right? Or about services too. There are also, I mean, there are things you can't say, I've won every case I've ever tried. You can't just say that, right? But political speech is different. Yes. Content neutral, let me think of something that's a good example. It would violate viewpoint neutrality. Maybe we'll put it this way. It would violate viewpoint neutrality to say, you're welcome to talk about the war in Iraq as long as you support it. Right? Whereas content non-neutrality would be, you can't talk about the war in Iraq. You can have a rally about anything you want, but not about the war in Iraq. That would not be content neutral. That would be content discriminatory. It would be viewpoint non-neutrality to say, you can talk about any subject you want, as long as you take the government side. Right, that's the difference. So, yeah, you can talk about abortion in your after-school group, as long as you're against it. Right? That's a violation of viewpoint neutrality. So the idea would be, the entity that has enacted that regulation is saying, oh, we're content neutral. Right? Of course, they can talk about any subject they want, so long as they adhere to the school district's position on the subject. Right? So that's the difference. Okay? All right, number 12. Who's next? Okay. Page 44.
In the subsequent prosecution of Smith, the first
Your 12 is not my 12. I'm on page 44. Are you on page 44? Yes. Okay.
Statute prohibits all speech, picketing.
All speech making.
All speech making, picketing, and public gatherings of every sort.
So it starts out looking dangerous, right? Because it's looking like a total prohibition. Go on.
On the Capitol steps, in front of the main entryway between 7:45 a.m. and 8:15 a.m. 11:45 a.m. and 12:15 p.m. 12:45 p.m. and 5:15 on Capitol working.
All right. So how big a restriction is this? I mean, that's not a question that has a right answer, but it's just to get a rough and ready feeling. How big a restriction is this?
It's
I mean, if you look at it, it's 2 hours in the aggregate of a whole working day, only on capital working days, only on the steps in front of the main entryway. So there's at least one other entryway where you can go. You can be there on the weekend. You can be there at night. What looks like it would be the justification for this, given those times?
Reasonable ingress and egress of both working and the
Right. People are coming to work, they're going to lunch, they're coming back from lunch, and they're leaving. And they don't want to have to fight through a crowd of protesters to do it, right? That's the feeling that you get from this regulation, right? Probably constitutional or probably unconstitutional. Right, it's easy from that point of view, and so the issue is going to be distinguishing between two different answers that both find that it's constitutional, right? This is yes because, no because, no because. So take a look.
A constitutional, but on its face and Doe.
Okay, we don't know who Doe is. We're imagining some facts. Doe wants to protest at lunch, right? And that's the only time he has free, but he can't because of this, okay?
Constitutional on its face, but unconstitutional. Doe.
Okay, which is going to be the better answer? Yeah, this is easy. This is an easy one, right? Because what do we tell Doe? Use the south entrance for your lunchtime protest. Right, right, right. Okay. All right, so again, we look at C and D just so you won't be distracted by them. All right.
Constitutional on its face because it applied to all
No, there's vacations and weekends, and right. Right, even though it's a public forum, this regulation is still content neutral, right? This is a classic time, place, and manner restriction, right? Generally going to be constitutional, especially when you realize that it isn't very burdensome, right? Now, there are times when they can do a regulation like this, and it's very burdensome if you actually look at it, right? The additional facts. This is the only entryway, and it's open 7 days a week, and, right, we could add facts that would make this something that was trying to look like a content neutral time, place, and manner restriction that really wouldn't be. It really would amount to a total restriction. I mean, if it's, you can get a parade permit, but you can't have a parade on any weekend or holiday, or you get the idea of how it might look facially like it's just a content neutral time, place, and manner restriction, but when more carefully evaluated, you would realize it's a much more burdensome restriction than that, but not this. This is an easy case. Okay. All right. Next of the speech-related rules that we want to be sure that we're clear on is vagueness and overbreadth, and how those are related, though they're quite similar. And I think it's quite unlikely that you will be given a question that requires you to determine whether vagueness or overbreadth would be the better challenge, right? They'll probably be together, or only one of them will appear, though you do want to understand what the difference is between them. Also, I would suggest that you modify the note a little bit, just because, again, I think it's potentially misleading. The note on page 45 in the middle that should say, even regulations of unprotected speech are unconstitutional if vague or overbroad, rather than may not be, because to me, when I read that, I thought, but of course they can be vague or overbroad. It's just that if they're vague or overbroad, they'll be unconstitutional. So even regulations of unprotected speech are unconstitutional if vague or overbroad. Another way to put it is vagueness and overbreadth challenges apply even to regulations of unprotected speech. And I think it's a helpful way to remember that rule is that it has to be clear what speech is being regulated. Right? I mean, and obviously obscenity is probably the most heavily litigated area here, where people will say, sure, it's fine to regulate obscenity, but this isn't obscene. And so the law has to be very clear about what's obscene so that you know whether you fall within it. That's the other thing, right? Is there has to be fair notice to someone who might be violating the law. You have to know whether the conduct in which you're engaged is a violation of the law or not. Right? So vagueness and overbreadth, which we encounter in the free speech context, really also have broader application. They're general, fundamental principles of law, right? Every regulatory regime has to have laws that are not too vague or overbroad, right? Or they don't place people on fair notice of whether their conduct is in violation of the law or not. So these kind of basic principles of the rule of law that we're typically going to see in the free speech context, but we see it elsewhere too. We see it in criminal law. right? Criminal statutes can't be vague or overbroad. You have to know what conduct is being regulated, right? So the vagueness challenge is a reasonable person cannot tell whether the conduct in question falls within the law's prohibitions. That's the problem of too vague. Right? Imagine a law that said you can't speak out about any topic that will potentially upset someone. Right? Or a criminal law that said it's against the law to engage in antisocial conduct. Well, that's not good enough, right? That's not clear enough. It does not put people on fair notice of whether their conduct violates the law. Overbreadth means the regulation brings within it conduct that it either does not seek to regulate or that it cannot constitutionally regulate. So the example that I gave on the speech side would also be overbroad, right? That is, you can't engage in any speech that would potentially upset someone. Well, some of the speech that would potentially upset someone is core protected First Amendment speech. Some isn't, right? But a law like that would be overbroad because it would bring within its ambit conduct that cannot be regulated or, as the case may be, made illegal. Yep. All right. So, and then another similar challenge is, in the speech context, is a regulation that gives an official too much discretion in regulating speech or assembly. That typically comes up in places and in settings where there is a licensing or regulatory scheme, but what you have to do to get a license is left entirely to the discretion of some official who can then exercise it in a discriminatory way. So there is a parade permit procedure, but the bottleneck in that procedure is the approval of the police chief. And he approves what he wants to approve and doesn't approve what he doesn't want to approve, and there's nothing requiring him to be content neutral, and there's nothing requiring him to be viewpoint neutral, right? That's not good enough, even if a permitting process generally is perfectly okay, right? That is, it's not a violation of the First Amendment to require people to get parade permits. But then there has to be access to those permits and not vague or overbroad or excessively discretionary standards for the granting of those permits, right? It would be okay even to say you have to get a parade permit and we only grant 20 for the 4th of July parade, right? But it can't be the 20 the police chief feels like, right? It could be maybe first come, first served, or there are requirements for the permit. You have to tell them how many are in the group and promise not to have a banner that's flammable, or who knows what it might be, right? But it can't be whichever 20 the police chief wants to give the permits to this year, get the permits. Okay? All right. Number 13. Who's next? Yeah, okay.
Subsequent prosecution of Smith, the first one is Smith.
All right, so we've got no idea. For all we know, this is a criminal law question, so we've got to double back. Okay?
A newly enacted state criminal statute provides requiring no person shall utter to another person publicly any disturbing or unwelcome.
Right, so it's a criminal law, which means we have the concerns that we have about vagueness and overbreadth are kind of doubled, right? It's a speech law and it's a criminal law, right? And so definitely with respect to criminal law, people always have to have notice of whether the conduct in which they are engaged would violate the law. Okay, go on.
Smith followed an elderly woman who was watched down the public street, yelling in her ear offensive four-letter words. We asked Smith to 01. Subsequent prosecution Smith, first statute Smith.
All right, so we've got the statute, and now we have to figure out, can he be convicted? And I don't know if that's even quite the way the question would be framed. It might be, in his prosecution, what would be his best defense, right? So the and this is also, notice, not a yes because, no because, no because. It's a yes and then 3 no's, right? So if he can be convicted, impliedly, the statute is not constitutionally infirm, and he did it, right? So we're going to read through our answers to see, does it seem to you that he can be convicted? Because, just without looking at the answers? Right, whether it's vague or overbroad, I mean, you can see the overbreadth issue is that it will overlap core protected political speech, because especially unwelcome, right? People may not want to know, right, that there are gay couples who seek to marry or whatever, right? So unwelcome is especially overbroad and maybe also especially vague, right? Because how do we figure it out? How do you know in advance, et cetera? Yes, which is also problematic. Okay, so start at B.
B, cannot be convicted because speech of the sort described here may not be punished by the state civil authority.
Okay.
Say that if you have.
Well, right, it's not a horrible answer. It would kind of depend on what the other answers are, right? Because some of this speech can be, right? Some of it can't be regulated. Right.
Yeah, I mean, the statute is that doesn't sufficiently define the speech.
Right.
To be able to go to the next step of placing it within the.
Well, right, and
third order.
right, and some such speech can be, I mean, that is, I'm going to kill you, right, where it raises a reasonable apprehension, et cetera, right? So, again, it's not a terrible answer. There may be a better answer. Let's go on.
C, cannot be convicted because though the speech here may be punished by the state may not do so under the statute.
Maybe better or worse than the prior?
I would go with worse.
Do we not?
No, actually, I would go with better because you could do it if you whatever you feel that works.
Right.
You can't do it under that statute.
Right. The question is, could a proper statute reach this conduct? And I think the answer is maybe it could. Whereas the prior answer suggests there is no imaginable statute that could capture this conduct. Right? So again, if B, there are possible worlds in which B would be the right answer, but I think C is allowed to intimidate them, right? Doesn't mean you're allowed to assault. You can't engage in conduct that would put a reasonable person in apprehension of an imminent battery, even if the person you are threatening says bring it on, right? That is, it doesn't make it not an assault that they say, oh, well, go ahead, I dare you to do it, right? Because that's not the standard that we use, right? And again, it's also a little, the facts here are not as clear as they might be, right, about whether this is what the average person would think. I mean, if it were just gibberish, but even gibberish, you might be scared. This is a crazy person who's going to hurt you in some way, right? So I think in this setting, C is our best answer. Okay. The next of our rules has to do with prior restraint on speech. That is, regulations that prohibit certain types of speech rather than punishing them, right? They're the flip side, right, of the law that criminalizes the speech. It's the prior restraint on speech. The issue of prior restraints often arises in relation to a permit or license requirement, right? But that's a valid prior restraint if it's proper, right? To be valid, a prior restraint must have narrowly drawn, reasonable, and definite standards. An injunction must be promptly sought, and there must be prompt and final determination of the validity of the restraint. Right? So this has to do with licensing requirements, people's compliance with them, their challenges to them, right? Because sometimes what will happen is someone will seek a permit, they won't get it, and they will speak anyway. That is, they will participate in the parade without a parade permit, and their argument will be, we tried to get our permit, they refused to give us our permit for unconstitutional reasons, and so we don't need no stinking permit. Because their permitting process is itself unconstitutional. So that's the kind of litigation is either denied the permit, plan to participate in the parade anyway, or they apply for a permit and they never hear back, right? And it's getting closer and closer, and they proceed, even though they never heard back about their permit. So then they're arrested, fined, whatever it is, because they have participated in the parade without a permit. Then they challenge the permitting. They challenge that conviction on the basis that the permitting process itself is unconstitutional prior restraint. So that may include the too much discretion in the guy. That's a possibility, but there are other ways that it also might arise. Okay? So I don't think we have a question that's just about that, but the situation is the one that I have just described. So you want to be able to recognize that, right? And that a proper challenge to such a permit would be a permitting process that places all the discretion in the police chief, who doesn't respond, right? As of the morning of the parade, they still have not heard back from the police chief. They participate anyway. Or the police chief every year just gives permits to organizations that have this politics and not those politics, even though they've complied with all the permitting requirements. Then they could bring a challenge to the need for a permit as an unconstitutional prior restraint because of the way the permitting process works. So you can see how what a question like that might look like. All right, our next topic is, again, sort of about wrong answers, including the scope of the obligations of contracts clause, which, as we see described in our materials, prevents states from making laws that interfere with contracts that people made before the laws were passed. So it's about impairing the obligation of contracts, undoing, as it were, the private arrangements that people have entered into. And this, one of the ways that this has come up historically, not something so likely to happen now, but the classic case of impairing the obligation of contracts is permitting your state's residents not to perform on contracts they've made with out-of-staters, who then come into your state to seek enforcement or damages, and you won't hear them, right? Because you say contracts of that type, right, we will not enforce, or we won't enforce them against our residents. That undermines our federal system, right, in the same way as burdening interstate commerce. So it kind of has, in terms of its historical and theoretical roots and justifications, kind of like the Dormant Commerce Clause, right? It's a way that a state could discriminate against people from out of state by impairing the obligations of contracts in favor of their own residents. It's not something that we think of, I think, very much in our contemporary context, or at least we didn't for a long time. I think getting a sense of the politics of that, not an impairing the obligations of contracts issue, but getting a sense of it in the contemporary political context, is the refusal of some states to recognize the same-sex marriages of states entered into elsewhere. The idea that the politics of one state would be used in this way to discriminate against out-of-staters is really an issue that has not been so much in the forefront of our political consciousness for a long time, but it's back, right, thanks to this marriage issue, which I think gives us a sense of, to the extent that, depending on what your politics are, to the extent that you may have some sympathy with, at least at a political or theoretical level, with states that do not recognize same-sex marriage, who feel like it is being forced on them, right? And so, again, it's that way of thinking, even though that's not strictly a contracts issue. Not very. Do I think that a community property question on the California bar exam will involve a same-sex couple sometime in the next couple of years? I think the chances are probably 100%. But your exam was written before Perry was decided. The exam you're taking was already in the can, right, before June of last year. So the chances, 0, right, for this year. So, whatever, I'll buy you a drink if I turn out to be wrong, but I'm not going to turn out to be wrong. Also, of course, there's some complex timing issues now, right? Because there's that little window in 2008, and then right, and whatever. And so people will be confused for a little while, because again, for community property questions, I mean, this is a digression, although it's very interesting. Community property questions generally are going to require people to have been married for long enough to accumulate and have some passive assets and inherit some, so you can get the question going, right? So unless they test somebody married during the window in 2008, they're not going to do it for a while, because they're going to want to tell you that the couple got married at a time when people are not then having to remember, could they get married? Did they get married in Massachusetts? Are they going to test some complex interstate? They're not going to do it. So I would say it's coming. Absolutely, it is coming, but for the next couple administrations, no. Okay. All right, so now on to the impairment of contracts. And question 14. Okay. All right, so that's also sort of a weird question. Most clearly and easily, right? Because this is not, there seems to be no suggestion here that this would be unconstitutional. It's sort of obviously constitutional. And then the question is, what's the best argument for its constitutionality? You think, what difference does it make? Right? Right, that is, it matters what's the best argument against something's constitutionality. It doesn't really matter what's the best argument for it, right? Because that's not the burden, right? But in any case, so let's work through our answers. Right. No taxing and spending, right? So, what do you think is our best answer? Right. Who is regulated by the 14th Amendment? Whose action? No. Yes, it has a state action requirement, and this is not a state action. This does not prohibit any state from, right? That's why this is weird, right? Because it's like trying to prevent individuals from doing this, right? And so what do we think is our best answer? Yeah, I think C is our best answer, although it's weird, right? This is like a badge of servitude question, sort of, but this is also a process of elimination and recognizing what doesn't belong.
Because, right, because 14th Amendment
It
really
has a
applies
state
to
action.
states.
Yeah, it has a state action
This
requirement.
is a statute which is against
Individuals. Right, so the question is I think there's some question as to whether, under what provision it would be constitutional, right? And so I guess, among these choices, the 13th Amendment is clearly the best choice. The likelihood of a 13th Amendment question coming up is pretty obscure, right? Because this is this badges of servitude. Is that right? Oh, an essay question about it. A con law question? What was the content? Oh, okay. Arguing that this is involuntary servitude. Okay, so wasn't race-based. It was a 13th Amendment question coming from a different direction. Okay. It was horrible. Hard to answer, you mean? Hard to analyze?
Yeah, because it was just kind of like, wait,
What are you supposed to say?
where does this even go?
I
It
see.
doesn't fit many things, and I don't
No.
know. I've never really
Thought about it.
concentrated on the 13th Amendment in my con law studies.
Right. Yeah, no,
I
it's
know, I thought
obscure.
everybody, like, you look around the room, everybody's like,
Oh
what
my
does that
God.
mean? Where do we go with this?
Right. Well, I suppose you're protected from the likelihood of its recurrence. All right. Turn to page 47. And the regulation of aliens, which also kind of goes back to that question that whose facts we didn't know, right? Or state of Yuma, you can only hire citizens, right? It also, I think, would fall under this heading if we were rearranging materials in some ways, right? And the reminder is states can welcome and regulate the huddled masses, but ultimately Congress has control over matters concerning aliens. And again, if we go back to that question, any state law inconsistent with federal action, treaties or laws, will be superseded by federal measures. So that was question, let's see who can find it.
Talk about the
Yeah, the state of Yuma. Right, so that's page 37A. You might make a note to yourself because those go together. We could put them together. It's question 7 on page 37A. And now question 15 is going to be another another one that involves aliens and federal law. Okay. If somebody has a pen I can borrow, I will make a note to myself when I revise the materials. All right, see also question 7, page 37A. All right. Right, preemptively. He doesn't want to wait to be ejected. He wants to be able to use the land and not worry that at any moment he'll be ejected. Right, which is the state, right? And I think it would probably be phrased a little bit more clearly that way, right? His opponent in litigation is the state. He's suing the state, seeking an injunction to prevent his ejectment on the basis that the statute under which he would be ejected is unconstitutional or otherwise improper. Okay? So what is his best argument? We've got 2 questions here, but again, as you know today, that it would not as typically occur that way, but we'll work through both of them. So best argument for him is what? Well, what's wrong with this answer is that it's too much, right? Forbidden from interfering, right? They can't unreasonably burden, right? Because, and also notice it's not, it's a little, well, it's also a little confused, right? Because there's a difference between non-residents and non-resident aliens. Now, they could say no one but a citizen of California can own this land, and that would prevent citizens, U.S. citizens who are citizens of Nevada, as well as non-resident aliens, as well as illegal, that it could reach everybody, and then it would be dormant commerce clause, unduly burdening, unreasonably burdening interstate commerce. But this answer is confused in a few ways, right? So you shouldn't be attracted to it. Go on. Yeah, I mean, there are better answers. I think we think of foreign relations and immigration as not having much to do with each other, but conceptually they are related, actually, right? Because our willingness to let people who are citizens of other countries enter and under what terms is actually part of our relationship with those countries. When you think about it that way, right? When you think if the United States were to ban immigration from country X, that would be a move in our relationship with country X, right? Whether country X would like it or not, right? If we would say we won't grant visas to them, right? We will not entertain their applications to become permanent residents. They can't come here and work, right? That would be a fact in our relationship with country X. Even though, again, we think of like foreign relations as one thing and immigration as about people who are here, right? In fact, they're part of something that is unified. So best possible answer, no, right? But at least in the ballpark, right? Because it's getting at that supremacy issue, okay? Right, irrelevant, okay? Right, this is also irrelevant, right, and too factual, right? A challenge that's going to come in, right, challenges that are going to be based on the constitutionality or otherwise are typically not going to have this kind of factual component. Now, if we're actually having to do an analysis of whether something unreasonably burdens interstate commerce, we may, or unreasonably burdens the outside, the non-state residents, we may have to do some of that. But this is a supremacy issue, right? This is a place where it's possible that there's a federal law, right? Or this is an area of federal control, and the absence of a federal law means a state can't do it. right, because of the burden that it would impose, right? It's like question 7, right? I mean, you should see its structural similarity to question 7, right, which is about you can only hire citizens, right? It's the same in a way, right? It suffers from the same problem. And so our best answer is B. Because that's what this is about. It's about the state's power to restrict alien rights, and that's a supremacy issue, right? Again, even when it's not obvious, right? And then question 16 actually asks us to predict the outcome, or not to predict the outcome, but jurisdictional. This is a jurisdiction question. It's actually a federal jurisdiction question, right? Is there federal jurisdiction over this? Yeah. I mean, it's a state law, but the argument is a supremacy clause argument. Correct. That is correct. Correct. Right. He's seeking an injunction, and the question is the federal court, another way to put this is, or a way to think about it is, would the federal court have the power to enjoin the enforcement of this law? Yes, if they find, right, that there's a supremacy issue, etc., right? But they have to find that, right? That is, they might ultimately conclude that they can't enjoin it because it doesn't have that issue. But it might have that issue, so they've got to hear it, right? There's always jurisdiction to determine jurisdiction, all right? So let's look through our answers. That's just false. Just false, right? Right, because not if it violates the federal Constitution, right? That would be like the state saying persons of a certain race cannot own land here. Yes, maybe, God only knows, but it wouldn't require them to dismiss the action. In fact, or here, I mean, it's just, yeah, out of left field. Right, and the only thing that makes that, I mean, there's something that makes that answer hard, and then there's something that makes it easy. What makes it hard is you're not exactly given the federal question. What federal question? What makes it easy is that the other answer is ridiculous, right? The other answer on the right side is ridiculous, right? That's not a source. I mean, you'd have to know whether and to what extent that's a source of jurisdiction in the federal court. Is it? I don't know, right? That's a whole different area of law than you're expected to know for this, right? So it's easy once you come out on the right side of it, right, and understand that even without the word showing up, it's a supremacy question.
Right. Once you get to the understanding that it is an issue of supremacy, then
Right. Of course, the federal court can hear it.
The court's going to hear it.
Right.
And once you see United Nations, you know the only other
Right.
choice
Is where you have to be. Correct. All right. Onward to page 48, and checks and balances, or AKA separation of powers. So the way that this is likely to come up is understanding who can do what, right, in terms of the exercise of authority. And we again have the frolic and detour, the little chart that we will fill in here on page 49, which we'll do, and then we'll work through the question so that we can put these together. So we'll do these in a vertical setup. So over what sorts of cases does the Supreme Court have original jurisdiction? What sorts of parties or subject matters? But this Supreme Court jurisdiction. Not original jurisdiction. Original jurisdiction means you file in the Supreme Court, not where you end up. You file. Who can file in the Supreme Court? Right, states, right, and the classic easy one to remember there is like water disputes and boundary disputes, right? They go straight there. They don't start somewhere else. Where else would they start? They start there. And then there are some special cases about ambassadors and, right, much less likely to encounter.
states can
and powers, right. Can start there. Appellate jurisdiction over everything else that they have jurisdiction over, right? So it's appellate with respect to everybody else. And then the writ, right? They hear cases versus the writ or appeal. Right, that you're not going to have to worry about too much. It's really just recognizing those rare situations in which a case can actually start in the Supreme Court. You're not going to be tested on, in an MBE question, on the fine-grained rules of how a writ of certiorari works. Right, that, don't worry about it. All right, congressional powers. Congress can remove executive officers by what means? What is that procedure called? Yes, impeachment followed by conviction. Right, so the popular mind doesn't really make a distinction between impeachment and conviction and sort of thinks someone who's been impeached has been convicted of something. Not so, but as a law student and lawyer, you're expected to know a little more, be a little subtler. Congress can delegate its powers to another branch if it does so, setting intelligible standards for how that will work. Can Congress appoint members of a body that has administrative or enforcement powers? They cannot. So cannot is the word to circle, or you can cross out the word can. And then there's a little advise and consent information there. And then Congress can give the president, the courts, or heads of departments the power to appoint inferior officers, including special prosecutors. Yes. For the appointment. All right. President or executive branch can or cannot remove high-level executive officers. Yes. Can grant pardons for federal crimes only. Can veto acts of Congress, but may then be overridden by two-thirds vote of both houses of Congress. Right. And again, you're not going to be examined at whether it was 2 weeks. Yeah, these are fine points. Unlike, you just need to have a sense of the general workings of this sort of thing. Cannot exercise legislative power without congressional authorization or declare war, etc. You've got some info there. Well, but then there's the War Powers Act, right? That's Congress, right? Delegating.
So, but under the War Powers Act, you can do.
Well, so long as it follows what has been delegated under the War Powers Act, which again, likelihood of examination I regard as very low. Right. All right, so now let's take a look at question 17. Yes.
The provisions of this statute that authorize direct United States Supreme Court review of specific decisions rendered by other state courts.
All right, so we're going to look, right, and there's going to be a statute that authorizes direct Supreme Court review of specified decisions rendered by lower state courts, that is not the state Supreme Court. What body has the power to enact such a statute? Who decides what the Supreme Court has jurisdiction over? Right, Congress, using the provisions that are in the Constitution. Congress then enacts laws, right? Like, who enacts every part of Title 28? Congress, right? So if this law was enacted by Congress to create additional Supreme Court jurisdiction, it's okay. Anybody else cannot do it, right? So it can't happen inside the judiciary and it can't happen inside the executive, but Congress can do it. Now let's take a look at the statute starting at the top.
Congress enacted a statute
Right.
providing that persons may challenge a state energy law on the grounds that it is conflict with the federal constitution, either federal or state law.
Okay, so it grants concurrent jurisdiction,
And it's done by Congress.
right? So far, so good.
According to this federal statute, any decision by a lower state court upholding a state energy law against a challenge based on the federal constitution may be appealed directly to the United States Supreme Court.
Right, so that's the scheme. You see the scheme they've come up with. Can Congress do this? Yes, right, because it is within Congress's power to expand or, in fact, reduce direct Supreme Court jurisdiction and what the road is, right, to the Supreme Court. And they have the power to create concurrent jurisdiction, right, similarly.
So Congress can expand and restrict.
Only the Constitution restricts it, right? So the Constitution just says, shall create various federal courts, et cetera. I don't know the exact language. Everything about what their jurisdiction is and what the road is to the Supreme Court is up to Congress. All right, so constitutional or unconstitutional? This is yes because, no because, no because. All right, so let's look at those two answers first, although then we'll look at the others also.
So A, constitutional because congressional control over questions of energy usage is
Okay, good answer, bad answer.
bad.
Right, because it's not subject matter.
Yeah.
That's not the issue. This is about access to the Supreme Court. It's not about energy regulation. Okay?
So B, constitutional because Congress can establish a manner in which the appellate jurisdiction of the United States Supreme Court is exercised.
Right, easy, good answer. Let's look at the bad answers just to make sure people don't get distracted.
C, unconstitutional because they infringe on the sovereign right of states to have their Supreme Court review decision of their lower courts.
All right, bad answer because?
Because Congress can basically skip over it.
And notice they're not requiring that they do that, right? The person who loses in state appellate court can go to the state Supreme Court. They're not being prevented from doing that, right? And so, not
It's allowing it.
correct. They're just creating it's like concurrent jurisdiction doesn't take you out of the state court, right? That they've also done that. You notice that makes the question easier. It would be harder, right, to figure out its constitutionality if it were actually purporting to deprive state courts of their right to review such a law. That would be dicier, right? Because then we've got supremacy and other stuff going on. Here, it's made easy.
But it's also a misstatement of state sovereignty as it's understood. Because is there a state sovereign right to have their Supreme Courts review decisions of their court? Is that a sovereign right?
Maybe. I think without like really getting into the guts of state constitutional law, which is a fascinating and complex subject that hardly anybody's under-attended to. Eugene Volokh has a whole thing about this because he thinks lots of constitutional litigation should really be about rights that people are given under their state constitutions, and everyone shouldn't be rushing to try to find and squish stuff into the U.S. Constitution that's probably not there, which is often in state constitutions. But I mean, that would be a complicated question whether again, that's why they've made this easy by not depriving the state Supreme Court of the right to review the jurisdiction, right? They've given the litigant the option. That's different than purporting to deprive the state, because the state Supreme Court is generally the only court that the state constitution will require you to have, right? That it's having a multi-tiered system of courts is not required. It's the way we arrange things, but it's not required. It's that court of last resort that's required, right? And so that would be a weird and that would be a much more complicated, much more difficult question if this purported to deprive the state Supreme Court of the right to review its own lower court's decision, because arguably there has been no final state adjudication if all you have is the lower court, right? The court of last resort has not spoken, right? That would be complicated and tricky. That they are not going to ask you to do, right? And then D?
Unconstitutional because under Article 3 of the Constitution of the United States, the Supreme Court does not have authority to review directly decisions of lower state courts.
Right, just not true, right? Article 3 creates, it does not restrict. Right? And in fact, what it really does is authorize Congress, it instructs Congress to create the federal courts. Right? But how they're going to do that has played out and developed over time. And again, the Title 28 is a creature of congressional action. Right? Title 28 is not part of the Constitution, it's part of U.S. Code, and that's Congress. Right? All right, now we finally have come around to the 10th Amendment, question 18 that we pulled out at the very beginning. The 10th is a trap, right? Meaning only that it is almost never the right answer. I mean, meaningless goes a little further than I might say, although even as the materials say, right, your law professors may have taught, your con law professor may have mentioned it. There have been, in recent years, there's been more cases and more discussion of the significance and the scope of the 10th Amendment, but that doesn't mean it's not going to be that it's likely to be a right answer. It isn't. So we had question 18, which we looked at the very beginning. We can just take a quick glance back at it. Unlikely to be the right answer. We talked about it in the other context. We did it out of order right after question 2. This was the bicycle law, right? Registration of vehicles reserved to the states under the 10th Amendment, not likely to be correct. Then we have another one here, another thing unlikely to be correct. The Privileges and Immunities Clause. Again, as our materials note, and it's confusing when you first undertake the study of constitutional law, the Privileges and Immunities Clause, there are 2 different Privileges and Immunities clauses in the Constitution, only one of which means anything, or rather only one of which has given rise to any substantial jurisprudence, and that is the one that is in Article 4, the one that prohibits states from discriminating against non-residents. And as we have seen, most of that now plays out under the Dormant Commerce Clause. That's the form of discrimination, that is discrimination in commercial life, is the way that has typically played out. And the Privileges and Immunities Clause of the 14th Amendment, there's really no action there. There is no jurisprudence there. That's just not where it happens. So there are other parts of the 14th Amendment, obviously, which have given rise to a huge jurisprudence, but not that part. And so you want to be aware of it. Also keeping in mind that Article 4 might be relevant, but that the one in Article 14, very unlikely. Question 19. On page 51A. Second to last page of our little unit here. This is the state of Aurora.
Yes. The requirement that candidates for license must be graduates of barber schools in Aurora is probably...
All right, so this is the classic, right? It's the classic state licensing scheme. Are state licensing schemes usually constitutional?
Yes.
Yes, they are usually constitutional. Now, this one is going to require that you be a graduate of a barber school in Aurora, that is in our state. You can see that that's a little burdensome, right? Because you might very well have gotten your barbering license in a next door state and you want to come into Aurora and open your barber shop, and you can't just pay a fee. You can't just show them your license. You actually have to be a graduate of a barber school in Aurora. Ironically or otherwise, the process you are about to undergo is the correlate of this, right? That is, you don't have to be a graduate of a California law school, but you have to take the California bar exam. The bar is a licensing scheme. There is some states make their own decisions about reciprocity. Some states will allow, in effect, the license that you earn in California to be a license in their state. Because you can only go to law school once, they can't require you, right, to be a graduate. And that would probably be unconstitutional, right? To say to be admitted to the California bar, you must be a graduate of a California law school. That probably would be unconstitutional because you can only go once. But that you have to take the California bar exam, absolutely okay, right? Which is just it's another version of the same thing, right? Because you can go to barber school again. It's not like law school, right? And so even if you have your California barber cosmetology license, which we have, cosmetology is also a licensed profession in California, you can go more than once, right? So it isn't an absolute bar, right? Like requiring someone to be a graduate of California law school would be, because you're not allowed. Even if you were willing to go to law school again, you're not allowed.
By what?
I think in most places you can only get one JD, right? You could apply for a second JD, but it's disqualifying. That is, to actually already have a JD is disqualifying, right, for admission. Well, it might not be insane. There are all kinds of reasons why you could imagine wanting to go to law school twice, but they are the reasons you're not allowed to go to law school twice, right? You hope you do better the second time around, right? All right. So licensing schemes and their restrictions are commonly tested. It's very likely that an MBE question will in one way or another involve a licensing scheme. All right, so is this requirement that they be graduates of barber schools in Aurora, right? That's the question. Is that going to be too much? Like a requirement that someone be a graduate of a law school in California would be too much or not? So let's look through our answers.
Unconstitutional as an undue burden on interstate commerce.
Right.
That's a potentially.
Right, that would be the strict correlate, right? You have to be a graduate of California Law School to be admitted to the California bar. Clearly unconstitutional, right, as an undue burden. Okay?
B, unconstitutional as a violation of privileges and immunity clause of the 14th Amendment. You know that.
Right, because that's the 14th Amendment one that never is right. Okay?
Is there any jurisprudence that developed under that 14th Amendment privileges and immunity clause?
Not really. Not really. Yeah.
Okay, so C, constitutional because the state does not know the quality of out-of-state barber. Well,
Maybe. Right, maybe. And
yes, yeah. D, constitutional because of barbering is chosen. No, because barbering.
I mean, barbering is a privilege, right? Like the practice of law is a privilege. They can restrict you, right? But can they restrict you by making you go to a barber school in Aurora as opposed to, for example, making you take a barbering exam, right? Which is not burdensome the same way, right? So what we're choosing between is really A and C, right? That is the concern that they don't know the quality of the out-of-state barbering schools, right? Is that enough to require you to go to an Aurora barbering school, right? And think about this in the context of the exam you're about to take, right? California might say, how do we know what's going on in these law schools and other places? But the way they handle that is by making everyone take the bar exam, right? That's okay. Requiring you to be a graduate of their barber school means you have to move here and do this and this and this, right? And so I think if we think about this on an analogy with law school, that helps us to see, right, why A is the superior answer to C. Though there are other facts we could be given that might change that, right? That is, if we were to find out that Aurora has many 4-week barbering programs that are offered at no cost to, right, then it would stop being an undue burden like that, right? Or you can opt out of this requirement by showing your license from another state. Well, then that would also be different, right? Because in fact, that is how the California bar works, right? That is, it anticipates that most applicants will have attended a California law school, but proof of graduation from a non-California law school is good enough, right? To enable you to sit for the exam, not to let you opt out of the exam, because California doesn't practice reciprocity and it's not required to. Right? As California doesn't have to say, if you pass the bar exam in the state of Washington, well, that's good enough for us. They don't have to say that, and they don't say that, right? But your graduation from a law school in the state of Washington is enough to allow you to sit for the exam. This is how it works, right? With which we're, the system with which we're all intimately familiar. And you can think of that as all licensing schemes legally are going to operate the same way as that. Where that can be required. Okay. Okay. Yeah, so I think that's good. And we can think of another way that question could be written that would be so-and-so. An alien has, right, because again, it's graduates of barber schools located in Aurora, reside in the state for 2 years, right? And so that's also, what they're doing is trying to bring money and people into their state, not just making sure everyone is barbering appropriately. So there's a lot to that law, right?
What you were saying is when you identified the language citizens of the United States, you immediately were able to throw out C because you knew it was going to be in the Constitution.
Yeah, well, they're really.
There are very few professions that can be regulated that way. Some federal positions. Okay. So, good rule to remember and good thing to look out for that makes it even easier, right? So you don't have to be analyzing from the ground up. All right, so our last little bit of review is our chart on page 51B. And you can fill this in either way, any way you want, whether these are the words that you want to use or use a yes, no, or a checkbox. relevant, irrelevant. I mean, there are different ways to fill it in. I mean, I don't know that you have to use the words limit, confer authority, or neither, but you want something that tells you how this operates. So we'll go vertically down through the states. So the 14th Amendment Equal Protection Clause limits or applies to the states. Yeah, I mean, that's the way that I would typically put it, that it applies to the states. I mean, it does limit the state ability to enact laws of certain kinds. The Fifth Amendment Due Process Clause, not applicable. Obligation of Contracts Clause, right, applies to the states, right? The states, it prohibits states from impairing the obligations of contracts. Privileges and Immunities Clause of Article 4 applies to the states. Privileges and Immunities Clause of the 14th Amendment applies, but you might put it in parentheses, applies but rarely tested, or applies but rarely relevant, something like that. And I would, for Commerce Clause, what I put in that box is Dormant Commerce Clause. Applies, because that's the issue for the states. The General Welfare Clause of the Constitution does not apply, but if you want to fill in some details, right, states for state law have a welfare power and police power. You always want to be keeping track of whether the law in question is a state or federal law. And then to run down the federal side, 14th Amendment Equal Protection Clause does not apply. That's incorporation against the states. But the Fifth Amendment Due Process Clause applies. Obligation of Contracts Clause does not apply. Privileges and Immunities Clause of Article 4 doesn't apply, and the 14th Amendment also doesn't apply. Oh, could the federal government impair the obligation of contracts? Well, it might be a taking. I mean, there's an interesting and subtle argument, which is distasteful to many people, myself included, but that's not to say it's not an interesting and subtle argument, which is whether the Emancipation Proclamation was a taking. Right, and if not, why not? Right, that is, how do you explain why it wasn't? That is why what had been recognized, I mean, that is, was it a taking, right? Did it take, I mean, certainly many people suffered absolutely devastating economic loss because of it, right? And it impaired the obligation of many, many contracts. And there's some really, I mean, again, distasteful in some ways, but intellectually fascinating and challenging in terms of articulating what these concepts are in the conflicts of law area, right? So since clearly after the abolition of slavery, you could never enforce a contract for the delivery of persons. But what if the persons have been delivered and no payment has been made? Can you enforce the payment side, right? So does mutuality of remedy mean the answer to that is no, right? You've delivered the persons. Can you demand the payment? Well, now the persons don't have a property value to the recipient. On the other hand, they may have had a property value to the recipient for the year you waited for them to pay in the middle of the Civil War in a state that recognized slavery. Now the war is over. They never paid you. They're never gonna pay you. Very complicated. So there really is some very complicated stuff. There also are a lot of antebellum contracts where no money changed hands at all. Payment was to be made in persons, right? So it's persons for goods, no money, right? And so the goods have been delivered. You can't deliver the people. Is there a remedy, right, for the sugar that was delivered, that was supposed to be exchanged for slaves never delivered? Or does someone just get unjustly enriched because they got the sugar and didn't pay in the slaves, and they're not paying in money either? How is that supposed to work? So there's a lot of really complicated, fascinating stuff in this area. That having been said, right? I think that there are interstate commerce issues, right, that would allow, in that sense, the federal government to impair contracts. I mean, another example would be contracts for pelts of an animal that is then put on the endangered species list. So you've paid, they can't deliver the pelts. Are they entitled? What's a pelt? Oh, it's the fur. The fur, right. Oh, that's okay. Right, so if you've spent the money, right, what happens, right, but is that the federal government impairing the obligation of the contract by rendering it impossible? But that happens, right. So again, I don't know that we have a constitutional law issue there, but certainly the world changes in ways that sometimes impair the obligation of contracts. That's different than saying if state A resident sues our resident, they can't recover. But if an in-state resident sues our resident, they can recover. Right, so with that you clearly cannot do as a state, right? So I think we just think of this as not exactly applicable in the same way to the feds.
That's why they included the fourth paragraph of the 14th Amendment, which basically barred all claims arising out of the freedom of slaves.
Right.
They
Yes, but it's purely political, and that the question is, can it be justified legally, right? What's the legal argument for why it's not a taking, right? Not, well, because they said it wasn't. Yeah, well, that's not a legal argument.
Some things don't have a property asset.
Well, but they were, and then they aren't anymore, and that's what's so, I mean, it's tremendously fascinating. I mean, again, it has many distasteful aspects which, can make it difficult to write about or talk about in the right sort of way that does not seem offensive in other ways. But the law of slavery is a fascinatingly complex subject that involves brings to light many deep tensions, right, in the law that lurk all the time, even when not in such an acute situation. Yeah. Okay. All right. Privileges and immunities clauses, both of them do not apply to the federal government. That is, by their own terms, they apply to the states. The Commerce Clause, the Interstate Commerce Clause, is a primary source of authority for the federal government's regulation. And then the General Welfare Clause, the key is to remember tax and spend. May tax and spend for the general welfare, but not otherwise. No. We're now at 3 hours. I mean, we had a 4th hour allocated if we needed it, but we've got time, so. Okay. Is it an MBE question? All right, well, let's at least look at it, and if I don't know what I would want to say about it, then we will defer it, or we'll do it by email. Okay, okay. 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 Okay, well, we'll see. Okay. Right. Yeah, that's clearly relevant because, I mean, if we think of, the classic restriction that is thought of as enhancing value, again, there's fascinating stuff that underlies this, but the restriction to residential use only is the restriction that is most typically thought of as enhancing value. That's the thing to be protected, right? So if someone can now have a transmission exchange next door to their mansion, they're not going to be happy about it, right? So that's an example of why takings will be relevant, right? Because the loss of that deed, somebody buys in a residential neighborhood in the belief that there will be nothing but residential houses on that neighborhood, and then before you know it, there's an adult bookstore and a transmission exchange and a fireworks factory or whatever. So that's takings. Potentially.
C is sovereign immunity, and this is the same.
Mhm. Okay. Okay, and your materials suggest which is the bad one? I mean, I think the police power is also okay because this is what they're trying to do. That is, they may have to compensate to do it.
C is the answer. Yeah. So that's not the answer. So between C and D, I think they all seem relevant. I mean, if the state is restricting my, so anyway, I can see why.
Is not the relevant one, right? But it's not right. It's that you can't. Sovereign immunity isn't relevant because it's not going to help you because this is the state acting as the state. This is what they're allowed to do. They may have to compensate you for the taking, but this is what they're allowed to do.
I mean, the question is also odd because there's least likely to be a consideration. I mean, if I was working,
Right.
if I was counsel, I would
Well, but I think I think what they mean is, which is again, it's not a terrifically well worded question from this point of view, is which one is least likely to be a problem, right? And sovereign immunity isn't going to be a problem. Sovereign immunity is going to be a solution. It's not going to be a problem, right? The taking is a problem because it might make things expensive. The impairment of contracts is potentially a problem, right? And whether this falls appropriately within the police power, this is something you're going to have to justify. But it's the state acting, so of course sovereign immunity is going to help you, not hurt you. That would be another way to think about it. Which one of these is likely to hurt you and be an obstacle to this scheme? And sovereign immunity isn't an obstacle to the scheme. Sovereign immunity facilitates the scheme.
So sovereign immunity is
No. Right. Sovereign immunity is the answer because it's the least likely to be a problem. Okay, that's it.